want to turn it over to one of our fabulous attorneys over at the Pompano Beach office of K. Bender Rembam, our instructor for tonight, Emily Gannon.
Thanks, Jeff. Hi, guys. Jeff, yeah, we're gonna have to go over some of the logistics again from what I see in the question and answers already.
Let's see here. I missed the first part. This is not count. No, this counts for HOA board member certification.
Right.
We don't know if it's going to count for continuing education. That is not clear from the division yet. If you are, is there an exemption for the certification requirement if you are an attorney? If you're a board member of an HOA, you need to take this class, no matter what your profession is, right? Yeah. Whatever your profession is, you got to take the class if you're a board member. If I need to swap my laptop, will it still count me in? Yes. Let's say you have a technical issue where your internet drops for a second, you get cut off, and then you come back. I will be able to see that on the Zoom attendance sheet. I'll see you made the effort to come back. We're not unreasonable. You'll be okay. I am the president of a condo, HOA by default.
Right. I'm not sure what that means.
Not sure. Yeah. If you're in a condominium, all right. Condominium and HOAs, they're two different things.
Right.
718
Are you governed
for
by
condos.
chapter 718 or 720?
Right. And if you're not sure, if you're not sure, I would say just hang on. But if you're an HOA, single family homes typically versus units in a building, that's typically the difference. Although not always, but that's typically the difference. Not always. Okay. If you have a husband and wife on the call, could we get both? This is the thing, and this is what we had on the advertisement, folks. This is for Ricardo and Genevieve, okay, in particular, and anybody else. If you're watching, you must have your own unique registration, and you must log in separately with your own link that Zoom gives you when you register. We have to have proof that you were individually on if we ever get challenged by the state, or if somebody on your board says, hey, I need to prove so-and-so took the class, we need to know that you were actually here. So you still have a little time. Go ahead and register and come on in on your own. Right. If you're logging in, if you do want to watch together, register separately on your phone, hit enter, set the phone aside, and then go ahead and watch together. But we need something that shows you were individually here with your name and timestamp. Okay. So that answers Ricardo. Live outside of, the state of Florida, doesn't matter where you live. We just are co-hosting with Tamarac today. Private, Emily, private company HOA. What does that mean?
Don't know what that means.
Don't know what that means. My chat says disabled. I mentioned earlier, don't worry about that. We can send stuff your way. You just can't send stuff to us. I'm on a phone. Is that okay? Yes. I took an HOA course a year or two ago. Should they attend this course since there are new requirements? I believe that this course, even if you've taken one of the older cert courses and have continuous service, you're still going to have to take this by the end of next summer, I believe. Yes. So you might as well just stay here and take it, and you'll have your certificate. HOA, do I need to attend? I'm on an HOA team, our community of townhomes. If you're an HOA and you're on the board, you need it. If you're not on the board, you don't need it. Correct, Emily? I don't want to mispractice. I don't want to practice law when I'm not a lawyer. And
townhomes could be an HOA too. Townhomes are tricky. Some of them are established as condominiums. Some of them are HOAs.
Yeah. And folks, you don't need to type into the Q&A, hey, I'm here, can you see me? If you can see the Q&A, if you can type in the Q&A, you're here. Nothing more to do. Don't worry about it. You don't need to let us know you're here. I didn't put anything into the chat yet, Robert. Nothing's in the chat yet. Just, here, I'll put the word test in there so you can see it. So I just put the word test into the chat. I'm with a condo, Jeffrey Grazia. You can go. Yeah. HOA is incorporated. All associations we'd love to have you, corporations.
But you can go.
Yeah. How do we know? I am confused. This is the right meeting for an HOA. If you're a homeowners association. Guys. Yeah.
Right. It is HOAs. So you have to be governed by chapter 720.
Yeah. If you're not sure, just stay and take the thing. We'll be done in a couple of hours. So with that said, Emily, you get started, and I'll type answers to the questions that come in that don't require an attorney's answer, okay?
All right. Thanks, Jeff. So hi, guys. I'm Emily Gannon from K. Bender Rembam. As Jeff said, I'm one of the attorneys here. I'm one of the partners. I've been here 12 and a half years, something like that. Our firm's been around quite a while. We're up to, what is it, 22 attorneys, I think, something
Yeah.
like that. We have, I think 10 that are board certified, one who's board certified in construction law, but all we do essentially is community association work. That's what we do. We represent, for the most part, HOAs and condominiums, co-ops, occasionally developers, occasionally owners, but for the most part, the associations. So we like to do these educational courses. We like it when our board members are educated. It's great. It helps us. It actually makes our lives a lot easier. And now you guys have a lot of new things you're gonna have to comply with. So we want to make sure you're aware of all of it. All right. And as Jeff said, we are blocked for 3 hours. I am going to try to do this under 2.5, fingers crossed. There are a lot of slides here, guys. There's 200 slides. There's a lot of material. It is meant to be the HOA board certification class. So it is meant to cover sort of a smorgasbord of HOA topics. We're not going to get into sort of the nitty gritty of every possible topic. We're going to cover everything that we're supposed to cover so you get your certificates, and we're going to make sure we comply with what the state wants us to tell you. Don't worry about that. And again, you'll have the slides, so you can, at the end, you can go through it at your leisure. You can read through them, you can mark them up, you can highlight, you'll have all the information there. I don't necessarily need to read every word to you guys because, you know, again, do we want to be here for, I don't know how long that would take me, 5 hours maybe? I don't know. So you may hear me kind of skip through some of the things and realize that's why. So, all right. So again, meant to be a general class. I'm going to get through as much as I can and in the time we kind of have allotted, and then we'll hold the questions till the end. And then Jeff, do you want to explain how we'll do certificates and all of that? Then we'll do Q&A sort of after.
Yeah. That's what we'll do. So we'll go through the required material. I'll go, and while you're looking over which questions because we definitely won't be able to get to all of them. There's a lot, there's almost 300 of you here. We're not going to get to all the questions. So we'll pick a few. And while Emily's looking over the questions, I'll go over the evaluation process and the certificate process. Again, you'll do the Q&A, then you can head out. Then I will remain on to go over the evaluation thing one more time. And for anybody who's having any problems or issues.
All right, guys. So buckle in, grab a snack, and let's dive in here. All right.
And I'm going to take one more question I want to answer, Emily. There's a person here. Is this the right meaning for HOA townhomes? Again, it doesn't matter which kind of dwelling it is. If it's an HOA, this is the class you need. Okay.
You are governed by Chapter 720.
And HOA incorporated, every association, every community association is a corporation. All right. So if you're in an HOA, this is for Fred, you likely need to be here. Again, I don't have your docs in front of us here or Emily to interpret them. But if you're an HOA, this is the proper class. And again, every community association, a condo, HOA is a corporation.
Correct.
Okay.
All right. And again, guys, remember, this is all meant to be educational. So don't take it as, direct legal advice. All right, let's dive in. First things first, let's see if I can share my screen if we do this the right way.
No, you've got this. Technology is wonderful when it works.
It's always fun when it's me. I feel like my computer sometimes does not love me. All right.
And folks, you will get the slides at the end. You fill out, we'll go over the evaluation later. You fill out the evaluation and there'll be a link to get these slides that are being used this evening. So you will have these. You don't have to worry now about taking notes or anything. And this is also being recorded. So you'll be able to review this later on and watch the recording again if there's anything you need to rehash. And we'll have that on the firm website within a couple of days.
So Jeff, you can see we're good?
Yeah, we're good.
Going through? Okay. All right, guys, let's get into it. All right. So first things first, why are we here? Hopefully you guys were listening and this is not new information, but essentially within 90 days after being elected or appointed to the board, because you might have been elected or you might have actually just been appointed. Maybe there was a vacancy and there was a seat open and the board put you on. Within 90 days, you now have to complete this educational course approved by the DBPR. You have to submit a certificate that you've satisfied the course. And the certificate's going to be good for up to 4 years. And now you have to do it every 4 years. That's the other part of this, that was a little bit of a change. The educational curriculum has to have training related to financial literacy, transparency, record keeping, levying of fines, and notice and meeting requirements. These were the big topics, so to speak, ultimately, because, and we'll get into some of why these changes were put into place. But in the last couple of years, if you've been paying attention, if you watch the news, there were some issues with some associations and some record keeping issues, some money that maybe was not spent the way it was supposed to the point where some people were actually arrested. Money was allegedly embezzled. There was fraud. There was all of this stuff going on. And then part of that was, hiding the records to sort of cover that up, all of that. Notice and meeting issues, that they weren't holding proper meetings to cover up, again, all this sort of wrongdoing. We want to make sure that we don't run into those issues again. And so that's why now this has kind of become a new focus of making sure our HOAs are operating properly. So you'll see a little bit of a theme as we go through all this stuff. All right. If you don't file your certificate timely, you're going to be suspended from the board. Board can fill the vacancy temporarily. It's a little silly because then if you complete it, you're just back on anyway. You have to hold on to that certificate for 5 years. If something happens ultimately and the board, you don't have the certificate on file, or maybe it's not valid, something happened, it's misplaced, whatever it may be, a board member you realize didn't actually take the course, the board's actions that board member had voted on or had been a part of, those actions are still legitimate. It doesn't sort of void everything. So it's not the end of the world here. So this is what we talked about a little bit too, continuing education. This was a new requirement. These are the changes, some of the changes again that went into effect this year. If you are in an HOA that has fewer than 2,500 parcels, the directors now have to do 4 hours of continuing education each year. So that's in addition to getting certified. So again, the confusing part here is, does this count towards your continuing education? And our answer for you is, we do not know yet. Because we don't have an answer from the people who make that decision for us. So,
and I'm checking every single week.
Right. But this counts as your certified, or your certificate and your certification, but we don't know if it will count towards the continuing education. So 2 different criteria we have going on. If you're in an association that has 2,500 parcels or more, it's 8 hours of continuing education. So just be aware of that. All right. Chapter 720, and you already heard me mention that a couple times tonight. That's the part of the Florida statutes that deals with HOAs. So for a homeowners association, you are governed by Chapter 720 of Florida statutes. When you hear people say Condominium Act, that's an entirely different chapter. It's 718. Co-ops are governed by 719. Then there's timeshares, all that good stuff. You guys, for our purposes tonight, the big ticket Florida statute is Chapter 720. All right, so we'll dig into what that really means. Again, there's going to be a lot of information. We don't need to go through each, word on every slide, but just to give you sort of a basic idea of what's the difference between an HOA and a condominium, they are very different, and the statutes are getting sort of more and more different as the years go by. They used to be a little more similar and kind of worded in similar ways with a lot of provisions, but now they're starting to kind of go off in separate directions. HOAs essentially exist with or without the legislation. So you could have had an HOA before 720 had any say in the matter, so to speak. Condominium associations are different. They are created, we call them a creature of statute. They're created by the statute by 718. So there are some differences. Again, we hear sort of the term HOA thrown around, and a lot of people call any association an HOA. It just sort of is a term of art where people will say, my HOA did this, or my HOA, costs me this much a month. And they may or may not be talking about an actual HOA. They may be talking about a condominium. They may be talking about a co-op, or they may be talking about an assessment. We're sort of using the phrase in a million different ways. But for our purposes tonight, we're talking about an HOA, which is a homeowners association governed by Chapter 720. Different from condo. We're not talking about condos today. All right. again, couple different things in terms of what chapter 720 applies to. Essentially, it was designed to give some procedures to homeowners associations and to help guide with the operations. It's not going to apply if we're talking about a commercial or industrial parcel community. That's why when that gentleman said it's a professional association, I'm not sure if that's what he meant, if it's a commercial association or something like that. That's a little different. So again, without looking at your documents, I wouldn't really be able to tell you. All right. This is an important question that comes up very often for us. And it's a whole legal argument, and it is something that you should be aware of, especially because there have been a lot of changes to the statutes in recent years. So the question we often get is, so which version of Chapter 720 applies? Maybe our association was written or was put together and formed, and the declaration was written in the year 2000. Okay, so does the year 2000's laws control, or the statute changed this year, so does the statute from 2024 count? That's often the question. Now, and I'd love to give you guys just black and white answers for everything, but unfortunately, that's never how it works for us, right? So it's really going to depend. Contract law says that the law that was in effect at the time of the contract is incorporated into the contract as if it were written into the contract, but it's substantive law. So this comes into play when we're talking about certain constitutional rights, basically a vested right. There's constitutional due process to consider. Essentially, if it's well, let me just, I guess, go through this a little bit more. Kaufman language is something you should be aware of. So you'll hear that term all the time. You'll hear Kaufman all the time, or Kaufman. Some people pronounce it that way. The language that we're talking about when we talk about Kaufman language is chapters, your documents are subject to Chapter 720 or, Florida statutes as amended from time to time. That's the magic language. Those are the magic words, as amended from time to time. If your declaration has that phrase in there, then basically your developer or possibly the association council at some point, if it was amended, was building in the ability for your governing documents to change with the statute. So essentially, without having to amend every year, your documents would sort of change with the statute, go with the statutes. Instead of the year 2000 version, essentially, if you have this language in there, now your documents are subject to the Florida statutes in 2024 without having to do an amendment, without having to do a vote of the owners. You automatically just follow along with the statute. For a long time, that was good language to have in your documents, we would have said. Most attorneys would agree, because the statutes typically your declaration was probably a little more developer friendly than you would have liked. And if the statutes were being changed, it was probably in a way that was beneficial for the association, friendlier to the associations, and maybe that was better language to be able to work into your governing documents. Now, if that's not the case, if you don't have that language in there, so if you don't have Kaufman, if it doesn't say your documents are subject to 720 as amended from time to time, then there's a whole analysis that has to take place. Then it's, okay, so we don't have Kaufman language, so we don't change automatically with the times, so which statute applies? And now this is where we get into the whole debate of, well, the statute changed, but is it a substantive change? Is it a procedural change? Did the legislature say in there, basically, did they give us guidance and say this is something that will apply retroactively? These are all important factors. If it's a procedural thing, and the easiest example to think of, and I know it's technically not an HOA example, but the easiest example is in the world of condominiums, their elections are all done in the exact same way. And that's because the statute for condominium elections changed. And the procedure of holding an election changed. And we all follow what the statute says for the procedure of an election and the whole process of voting for board members in the world of condominiums in Chapter 718. That was a procedural change, easiest example to think of. Again, I know it doesn't technically apply to you guys, but it's the clearest example I have for you. Substantive gets a little dicey, so to speak, because is there a substantive right involved? Is it a vested right? And we're going to get into some things later on. So I want you to keep in mind Kaufman language, sort of put that in the back of your head, and probably slide 100 or so, we'll revisit. All right. Another thing to be aware of, as Jeff said earlier, you guys are actually, if you're in an HOA, your association is an entity. It's a corporate entity. It's a not-for-profit. It's also governed by Chapter 617, which is just the chapter of Florida statutes that deals with not-for-profits. And ultimately, just to be aware, that's something that sometimes can come into play, and you may be able to follow something that was in 617. But if there's any conflict, essentially now the legislature has clarified for us, if there's something in 617 and there's something in 720, 720 is going to control. It's sort of that argument of the specific controls over the general. Your 617 is kind of the fallback to fill in any gaps, but 720, chapter 720 is going to be the statute we look to first. All right, then we get a question about, all right, what if there's a conflict between what's in our declaration, what's in our articles, what's in our bylaws? Now, we include this slide, and I'll be honest, I don't know what this is from. It's an old sales, I guess, or advertisement. And so the expression is a little dab will do you. That's how you can remember it. Declaration, articles, bylaws. So dab, remember it that way. That's the hierarchy. Now, when I say that, keep in mind, again, these are different governing documents that you have for your community. Your declaration is primarily, we call it your constitution. That's the agreement that typically has all of your use restrictions. If you're a 55 and over, that language should be in there. If you have, lease restrictions, if you have ARC guidelines, all of that information, your maintenance obligations, all of that should be in your declaration. Your articles are what you file with the state to set you up basically as a corporate entity. Your bylaws sort of lay out your governing items and how many people are going to be on the board, when your meetings are going to be held, all of that type of information that should be in your bylaws. So sometimes occasionally there's a conflict between them, but that's your hierarchy there. All right, so we'll get into now some of these hot topics, so to speak. Membership meetings, start there. For the most part for HOAs, let's be realistic here. We know you guys don't have meetings very often. Typically, the big meeting is your annual meeting. That is usually where your election is held. And you have to have an annual meeting, the date, time, and place that's in your bylaws. So again, your bylaws lay all of that out for you. Your election is supposed to take place at that annual meeting. You could have a special membership meeting. Maybe you're voting on an amendment or, something like that. You could also have a special membership meeting if 10% of the voting interests petition for one and they want to have a meeting. That's another avenue available. Unless your governing documents require, the notice of the annual meeting doesn't have to have the description of the purpose of the meeting, but we suggest you do it anyway. For special membership meetings, then you have to have that description of a purpose. So if it's something to, again, vote on an amendment, vote on, maybe some sort of material alteration kind of expenditure, something like that, we put that in there. Notice requirements, hopefully you guys, this is pretty straightforward, but again, we're going to go through, these are the basics, so stay with me. Date, time, location of the meeting. If your bylaws don't provide a different notice requirement, then the association has to mail, deliver, or electronically transmit notice not less than 14 days before that meeting. You have to comply with that mailing notice by essentially filling out an affidavit that then stays in the official records, so that there is proof that it was sent out 14 days before. And you're sending that to everything, to the addresses that are in the official records of the association, or you can send it via electronic transmission if your owners have consented to receive notice by electronic transmission. So you can, instead of mailing, you can cut down on your mailing fees if your owners agree. Now, for electronic notice, this is important to be aware of. Your owners have to consent to do that. So you can't just say, hey, we're going to start sending you everything via email. We don't want to, use stamps anymore. That's not going to fly. So you have to make sure your owners consent to it. You may be doing sort of half and half or both, some electronic notice, some hard copies. That's all possible until you can get everybody maybe on board. But that's an option. The only thing to be aware of is if you're setting a meeting to do a recall for some reason, they don't let you use electronic transmission. Not really sure why, but sure. You can broadcast the notice. That's another thing. In addition to having having sent the notice, you can also have and posting it. You can then broadcast the notice. You have to have the notice in the agenda on a closed circuit cable television station or whatever it is that services the association. More important to be aware of is this new website requirements now. Your website posting by January 1st of 2025. An association that has 100 or more parcels has to post the notice and agenda of each membership meeting at least 14 days before the meeting. Notice has to be in plain view of the home page of that website. Or if you have a separate sort of page for notices, it has to be very clearly labeled. If there's a tab up at the top or whatever it is, it has to be very clear, conspicuous, very easy to find that it says notices. We don't want anyone thinking, we're trying to, meet in secret or something, and we don't want people to be aware. Nope, we want everyone to be aware. Put it on the home page or have a very, very obvious, tab there. Also have to post any document that is going to be considered or voted on at the meeting at least 7 days prior to the meeting. So be aware of that. The website stuff is new, guys. So 100 or more parcels by January 1st of 2025, you have to have a website up and running.
Emily, I just want to mention one thing.
Mm-hmm.
This comes up a lot, so I want to try to head it off at the pass.
Sure.
A lot of people are not familiar with the word parcels. Okay. It's synonymous with homes. If you have 100 homes in the HOA. So think of parcels. If it were a condo, that would be like units in the condo. So parcels are the amount of homes in the HOA.
Thank you. Thank you for clarifying.
You got
I
it.
forget sometimes we get so in the mode of what we already know that I don't even realize I'm saying things that might sound strange to normal people.
And folks, if I don't answer your question, Emily's going to take some questions at the end. Again, even if I know the answers, I'm not one of the attorneys, so that's why you'll see me answering some questions that are not attorney related and not others. So I just wanted y'all to be aware. Back to you, Emily.
Thank you. Yes. So to clarify, parcels, for some reason, the statute uses a couple different terms. You might think of it, the most common sense way to think about an HOA. Typically, someone will talk about their home, their lot, but it's you've purchased a parcel. You own essentially a piece of land that was from a plat that was established and may have been developed with a home on it. It may have been developed or a single family house, or it could have a townhome on it. It could have an attached villa home on it. Some other, or maybe it doesn't even have a house on it yet. Maybe it's literally just the plot of land. So for HOA statute purposes, they say parcel. So but all of that for our purposes tonight, those are all kind of interchangeable. But keep that in mind, because also when we say house, there's probably some land around that. So parcel encompasses all of that. So just so you know. All right, members' rights to participation. This is important to know when we're talking about meetings, because this comes up a lot. Owners have the right to attend all the membership meetings. They also have the right to speak at the meetings with reference to all the items that you've opened for discussion and the items listed on the agenda. The owners have the right to speak for at least 3 minutes. So you can't sort of cut them off. You got to give them their 3 minutes. But you can adopt reasonable rules about the frequency, duration, and other manner of their statements. You could have a policy in place, obviously, about maybe the tone or sort of courteous nature of speaking at your meetings. If your meetings start to get a little tense and a little heated, maybe we need to have some rules in place and sort of keep some order, and maybe that sort of thing. Nowadays, it seems that's happening more and more frequently. If you have a physically handicapped person and they've requested that they want to attend the meeting, but for whatever reason, they physically can't because whatever location you've chosen, you're going to have to basically accommodate that person and make sure that the location can address a physically handicapped person and make it accessible to them. Owners can tape record or videotape membership meetings. That's a big one to be aware of because we get that question a lot too. It may sound kind of simple. It may sound a little silly, but you can adopt rules about recording meetings, taping meetings. I've been at meetings where people, just will pick up their phone and they start recording. That is fine. But again, we can adopt some rules. It doesn't mean they can, walk up to the board president's face and hold their phone, in their face. That's not going to work. You can adopt some rules about that. Obviously, that interferes when we're trying to get business done. I've seen, owners show up with basically almost a full camera crew with, a old school, huge camera. So you can adopt some rules if that seems to be an issue. But ultimately, they are allowed to record meetings. That is allowed. All right, quorum. Quorum is a fancy, I don't know, scary sounding word sometimes, but ultimately what it just means is it means the magic number that you need to have a meeting, really. That's the basic definition for it. And now in your bylaws, and that's where you're going to be looking for this information, unless there's a lower number in there, for quorum, you get to use 30%. Statute lets us do that. So you may have old language, it may say a majority, it may say whatever else. If that's the case, we go with 30%. If you have a lower number, and sometimes the documents will actually have something like 20%, that's even better, because if we can hit that magic number, then we get to have a meeting, we get to conduct business, we can have our votes, all of that good stuff. Proxies are important to be aware of. You guys probably know all about them too, unless you are really brand new to the world of HOAs. Proxies, you can vote basically by proxy is the gist. So you might not have to actually physically attend a meeting. You might be able to cast your vote in advance and give it to your neighbor to hand in, or give it to the board member or whoever it is. Or, and we'll get into sort of the nitty gritty of what different kinds of proxies you can use, but basic criteria, your proxy has to be dated. It has to include the date, time, and place of the meeting for which it was given, and it has to be signed by the authorized voter for that lot. So if that's you as the owner, or if you have multiple owners and it's supposed to be the designated voting rep, basically. Proxies are only good for that specific meeting that they were given for. And then they expire 90 days after the date of that meeting. So if you sign a proxy now and give it to your neighbor for something, all well and good. They could go to the meeting. If the meeting is supposed to be, next week, and you're going to be out of town for the holiday, and your neighbor goes and represents you and hands in the quorum, your proxy for quorum purposes, all well and good. If that meeting gets continued, as long as it's within that 90 days, your proxy still is good. But if your board decides we're going to have another membership meeting in 6 months, that proxy is done. So it's only good for that specific meeting and then any adjournments of that same meeting. Also revocable at any point in time. So if maybe you give your neighbor the proxy, but lo and behold, plans change, you show up to the meeting, you can revoke your proxy, you can vote in person or be there in person if you want. General proxies versus limited proxies. This is an important distinction to be aware of too. Both of them are used for quorum purposes. So both can basically let you count as an owner to be present, to be participating, to be part of the meeting, and for quorum purposes. Now, in terms of how you're voting, these are very different things. A general proxy is essentially, okay, I'm going to give this to my neighbor, or again, I'm going to give it to my board member, whoever it is, and let them vote for me however they see fit. That might happen at an HOA election sometimes. Or a limited proxy actually indicates how you're voting. So you would have already checked off the box. I want to vote yes in favor of this amendment, or no, I'm against this amendment, whatever it is. If it's a limited proxy, that person is basically delivering your vote for you, but you've already cast your own vote. General proxy, you're giving that person the ability to vote for you. So there is a distinction there, but both count for quorum. Electronic voting, this is something that's gotten a lot more popular in the last couple of years, obviously since COVID. Very helpful. There are a lot of companies and a lot of platforms now that are making it a lot more reasonable, especially when we kind of factor in maybe some mailing costs if you do the electronic voting. it all kind of evens out. But the gist that you should be aware of if you want to do electronic voting is you have to have a certain system set up. You have to follow the guidelines. You have to have a meeting at least 14 days before. There has to be a board resolution adopted. So it has to be a board decision, a 14-day notice of that board meeting, and the board has to adopt a resolution. So I would suggest they speak to counsel and have the counsel, walk them through what the resolution needs to include and how to do this. It doesn't just mean you guys get to decide, oh, I'll just email my vote in. That's not how it works. You have to follow the statute. You have to follow the guidelines. The platforms that you need have to comply with everything. You can't just say, oh, I'm going to email the manager and let them know how I vote today. Not the same. So there are certain criteria you have to be aware of. Now, again, there's a couple of slides on this. You guys can read this at your leisure here. So that brings us to elections. All right, because again, electronic voting often used in elections. Important to be aware of some of these things to make sure you're doing your elections the right way. A vacancy on the board that's caused by the expiration of a director's term is filled at the election. Easiest way to say that is, hey, at the annual meeting, that term's going to end, so we're having an election to fill that spot. Great. Okay. Election has to follow the procedures in your governing documents. So again, this is one of the biggest differences between HOAs and condos. And I know I told you we wouldn't really talk about condos today, but this is one of the things I just need you to be aware of. Condos have a very, and I already said it once today, regulated system of how they have to do their election. Statute outlines a whole bunch of stuff. Okay. Very, very administrative code, very regulated. HOA elections, very different. HOA elections, you're following what's in your governing documents. You're looking at your articles. You're looking at your bylaws. You're following those steps. Very, very, very different. So if you wanted your election, by the way, to be more like a condo with 2 notices and notices of intent going out and all of that, you could do that, but you would have to amend your governing documents to do it. Otherwise, typically elections in HOA world are a little bit looser, and there's not as much, I guess, well, we'll get into it. All right. Candidate eligibility, we get that question a lot. So-and-so has a violation. We're not allowed to, whatever it is, have trucks in the community, and Mary has a truck, so can she still run for the board? Or, whatever it may be. Mary is suing the association because she had a slip and fall at the clubhouse. Can she still run for the board? That's typically sort of the tone of how these questions come up. It's important for you guys to know if they're a member of the association, they're going to be eligible to serve on the board unless they fall into one of these categories. So unless they're disqualified, and there's very limited disqualification criteria. So those scenarios, the owner who has a violation or the owner that's suing the association, that wouldn't stop them from being on the board. That is not enough to say, they shouldn't be on the board. Politically, and you might have issues there, but it doesn't legally keep them off the board. What you need to be aware of is if a person's delinquent on the payment of a monetary obligation on the day that he or she can last nominate himself or herself, then they can't seek election to the board, can't be listed on the ballot. And that's any monetary obligation. So, an assessment, fine, whatever it might be. If you've been convicted of a felony, and that's in Florida or another state where it's a similar charge that would be essentially a Florida felony, you're not going to be eligible unless your civil rights have been restored for 5 years. If you have a pending criminal charge, and these were some additional criteria that have been added too, which again, like I said in the beginning, there's a little bit of a theme here in terms of what we're trying to prevent with some of these changes. And this is one of them. If you have pending criminal charges of forgery of a ballot, felony theft, embezzlement, tampering with evidence, destruction of association records in furtherance of a crime, obstruction of justice, then you can't be elected to the board either, which, okay, sounds great. If you have pending criminal charges for any of those things, makes total sense to me. I wouldn't want you on the board either. All right, nominations. This is again, sort of interesting of how HOAs function and how their elections are run. You can nominate yourself if you're an owner to be a candidate. Now, typically the way this works is we come to the annual meeting, we see if we have quorum. If we have quorum, so if we have our magic number, maybe it's the 30%, then, you know, item number 2 on the agenda is the election. All right, we open up the floor, we take nominations. Who wants to run for the board? You know, you can nominate yourself, I'd like to run, or you can nominate your neighbor. Mary would be a great candidate. Joe would be a great candidate, whatever it is. Again, yourself or each other, doesn't matter. Great, we have a bunch of candidates, you know, good to go. And you can take the nominations from the floor. But there's another way to be nominated. If your governing documents have a process where you can be nominated in advance, then you don't have to do the nominations from the floor. Now, sometimes there's language in your governing documents about a nominating committee. It depends really on how that's done, and you want to talk to your attorneys and look at that language. If it's something where the owners are allowed to nominate themselves, that's going to suffice. If it's language where it's just, hey, we have the nominating committee and they pick their 3 favorite people in the community, then you have to still have those nominations from the floor, because you have to let other people, essentially you have to let an owner who wants to run be able to throw their hat in the ring. So typically it's nominations from the floor. But if you want to do nominating committee or nominations in advance, you can, but that has to be in your governing documents. So election day, if we end up, you know, taking nominations from the floor maybe, and we have 5 seats and we only have 5 people who are interested in running, then great, look at that. We don't even have to have an election. We don't have to hand out ballots. We don't have to count anything. We can just say 5 candidates, 5 seats. Great, you guys are our new board, done and done. If we have something where the nominations are in advance, not from the floor, then we also have to be aware if same kind of similar situation can happen. If we have that many nominees or that many candidates and that many seats, then we can just seat them. There we go. Typically, your term is going to be for 1 year. Those board members, the directors, are going to serve 1-year terms, but look at your bylaws. The bylaws sometimes are different. You can allow for longer terms. If the bylaws maybe have staggered terms, maybe you're electing, you know, every other year, it's for 2-year terms. Maybe you're electing 3 this year, 2 next year, 3 next year, you know, the following year, and they're 2-year terms, and you kind of split how you're doing the board. That's a common thing that happens a lot. So you have some consistency on the board. If you want that and you don't have staggered terms, that would be something you'd have to put in your bylaws. Ballots, once you get to the election, or once we do the actual process, you could have a secret absentee ballot. That would again have to be something spelled out in your documents in advance. If there's an election challenge, that has to be commenced within 60 days of the election, or after the election results are announced, technically. And that's something that would actually go through the division, even though you guys are an HOA. Your elections are still, they still go through the division. All right, officers, important to be aware, you know, your officers are going to be appointed essentially at the organizational meeting. Typically it happens right after the election. The only time, I think this is a fun trivia for some reason, the only time that directors get to vote in secret, so to speak, is at that election of officers. So if it's a little awkward, if you have a, you know, an organizational meeting where maybe the board members, it was, you know, a mixed board, and you're not really sure how people are going to vote in terms of who's going to be president, who's going to be vice president, who's going to be secretary, who's going to be treasurer, maybe you'd rather do that vote secretly, and they could just write it on a piece of paper. Oh, I'm okay with, you know, Joe being president. I want Mary to be vice president, whatever it is. But that's the only time directors get to vote in secret. So directors are the ones who pick the officers. The directors vote amongst themselves. If you've elected, you know, a new board of 5, new 5 directors, those 5 get to meet and decide who's going to be president, who's going to be vice president, who's going to be treasurer, who's going to be secretary. Often you hear the owners will say, well, but wait, I wanted Bob to be president. Well, they don't get to pick the officer spots. They get to elect Bob, or, you know, vote for Bob to be on the board. And then it's really up to the board and the directors to vote amongst themselves to decide who those officers are going to be. And also important to know, you could change officer spots at any point in time, 2 weeks down into the year, maybe the president decides I have too much going on. I don't want to be president. Can I do something else? And you rearrange, you reorganize. That's what we call it. You reorganize. And that's just done at a board meeting, typical board vote. You could do that at any point in time, 6 months into the year, whenever. Fraudulent election activities. This is something, again, they've kind of strengthened in the last couple of years because of the things we talked about and because of the lovely stories coming out of the news and coming out of South Florida in the last couple of years. So we want to make sure these elections are being done properly. There's no fraud. So now there's criminal penalties, guys. A person who engages in the following acts commits a first-degree misdemeanor. Now, in theory, these are things that probably would have been crimes in and of themselves anyway, but now we've added them to Chapter 720 to make them, extra criminal for you. I don't know. So it's basically, and you can read through the descriptions, it's committing fraud in the process of an election. So you're trying to bribe people for their votes, or you're threatening people for their votes. All of these things, or, forging a ballot, all of that now, first-degree misdemeanor. Now, again, arguably, those were things that you shouldn't have been doing before anyway. But now we're really making it clear. These are going to be first-degree misdemeanors. So, like I said, new laws. This was effective this year. Knowingly aiding, abetting, advising a person in the commission of a fraudulent election voting activity. That was a new little twist they added. There is an exception if you're an attorney somewhere in there. Having knowledge about election fraud, all of that, because again, we want to keep everybody on the up and up here. Vacancies on the board, look at your bylaws. If you have a vacancy, you're going to see whether or not there's another process, but typically just everyone else on the board gets to appoint somebody and vote to fill that seat. And that person would serve the unexpired term that was left. So if you did have staggered boards, possibly that term is maybe there's a year and a half left. That person still gets that year and a half. They don't have to be up at that next election just because you have another election coming up. All right, we'll get into boards. Okay, this is an important thing. Again, it kind of goes with our theme of today. Officers and directors have a fiduciary responsibility to their owners. You are supposed to be acting reasonably, and we say then you are protected by the reasonable business judgment rule. So you are supposed to be, as a board member, making decisions that you think benefit, your community, benefit the owners, nothing that, just benefits you individually, but what you would do for the community. That's how you're supposed to be governing sort of yourself. And you really should be doing what you think is reasonable, what someone in the same spot reasonably would believe is right. Now, again, reasonable minds can differ. It doesn't mean you've done something wrong just because one board member, thinks you should do X and one board member thinks you should do Y. Reasonable minds can differ. It doesn't necessarily mean, you did anything wrong. But if you're making your decisions in a way where another similarly situated director would make the same decision, you're going to be protected. You don't have to worry about sort of personal liability. Be aware of that. Something that's been coming up more and more often nowadays. Be aware too, you can use email as a means of communication, but you can't cast a vote via email. You are not supposed to be voting via email. You're supposed to be voting at your meetings. And this brings us to, okay, so what's a meeting? When's a meeting? How do we define a meeting? Now, and I wish I were kidding, but we do some classes at various breakfasts and lunches and things like that. And at the last one where I taught a legal update, I actually had some board members, and it ended up being, I think, 3 board members of a 5-person board. They came to the breakfast and they sat at a table and they were just sort of making small talk with each other and chit-chatting and talking about the legal update that I was about to present. And someone else saw them who was not a member of their community and said, "Oh, you guys are having an illegal board meeting." And that's probably one of my favorite examples I've seen. So the question is essentially, when does it become an actual board meeting? And I wish, again, I had a clear-cut, nice, clean answer for you, but I don't. Essentially, anytime a quorum of the board is gathered to conduct association business, that's going to be considered a board meeting, and that should be properly noticed and open to the owners. We'll get into when there's some exceptions for that, but that's the general rule. Now, it does mean when you're operating, conducting business. So it doesn't mean, in my opinion, coming to a, seminar.
Hmm.
But
What
some people
about
are extra
as
cautious about this.
as somebody formerly on the field? You know where I used to work, a huge place.
Yep.
How does a board get together to do research to present at a board meeting?
So that's another thing. Sometimes, and again, certain attorneys are a lot more conservative about this than we are. We like to think we're a little, practical when we talk about
Exactly.
things. What makes sense? Are you going to meet with a vendor? Maybe you're doing a landscaping project. The vendor wants to come show you, hey, we're going to do, here's the presentation to show you out front what the entrance will look like. I want to walk the property and show you, my plan to put these trees here, whatever. If you have a group of board members, and maybe it is a quorum of the board, but they are not actually making any decisions. They are not making motions. They're not, again, the big thing is not making decisions. They're not taking any action. They're not deciding, okay, we're hiring ABC Landscaping. They're just meeting with the landscape guy or with the sign guy to look at again, to walk the property, to look at what they're going to present. And then to me, that's really just a workshop. That's not a board meeting. And then you're going to take that information back to your board meeting, back to your properly noticed open board meeting, and then you discuss it. Then you can vote on it in front of your owners. You have that discussion, so nothing is a secret. Everything is nice and transparent. We met with the landscaper, we met with the sign guy, and he walked us through, this is the proposal. We brought a copy for you guys. We have copies here, whatever it is. And then have that conversation at your duly noticed open board meeting. But yes, if you have to meet with a vendor, maybe on site or walk the property, maybe it's a workshop to go over something. Again, not necessarily a board meeting in our opinion, but again, great minds can differ on that point as well. 48-hour notice, typically when we're talking about board meetings, there are some exceptions. 14-day notice if we're talking about a special assessment, if we're talking about a rule that's going to have to do with parcel use, then that's going to be a 14-day notice. Be aware, again, like we talked about websites, we need your websites to also post these notices. It has to be physically posted, all of that good stuff. Hyperlink to your website should be on there. All right, like we said, January 1st of 2025, if your association has 100 or more parcels, you have to have a website up and running, or an application or an app, as they say, website or an app where you're going to post the notice of any board meeting, the agenda, and any other document. So, maybe something like I said, if there was a landscape proposal or something like that, you would post that as well.
And I'll just mention too, as the firm's resident nerd, the word website, the word app, and the word portal are synonymous in this case.
Right.
So when you hear those terms, they're all talking about the same thing.
Right. All right. So like we said, members can participate in board meetings. They have to be able to go to those board meetings. They're supposed to be open. Those meetings are supposed to be open to the members. And there are some exceptions, and these are your two exceptions. These are the only two exceptions, guys. If it's a meeting between the board and its attorney to discuss proposed or pending litigation, or if you're talking about personnel matters. So those are the limited exceptions. Otherwise, the meeting should be open to all of the owners. So don't have your secret meetings and say, well, but we wanted to talk about something that we didn't think was appropriate for the owners to hear. That's not going to cut it. It's only personnel matters or pending or proposed litigation. And in the case of the pending or proposed litigation, your attorney has to be there or has to be on the call or on a Zoom or whatever it is. It doesn't mean the board can meet to talk about those things. Members, like we said, have the right to attend, the right to speak. You can adopt reasonable rules. Same thing we were talking about before. Handicapped access, we talked about that. Compensation, you guys probably know the deal at this point. You're not going to get compensated for being on the board unless there's something, maybe to reimburse you for out-of-pocket expenses. Maybe there's a recovery of insurance proceeds. That's about it. This is why we talk about kickbacks. Again, we're talking about sort of everything being on the up and up. So we got to be really careful. Those cases I was talking about in the news, there was some shady dealings going on. We'll say it that way. And I think there were a lot of vendors making friends with board members by giving them lots of stuff that they probably didn't have to pay for so that they could get these contracts. Because again, those could be quite expensive. It could be a good deal for some of these vendors. So you have to be very careful. There's a kickback prohibition. You can't solicit, offer to accept a kickback. That's anything that's of value, basically, where there's no consideration paid. And that counts for, your family members getting those same things. And now it is, again, crime, subject to monetary damages, 3rd-degree felony if you knowingly violate this prohibition. All right. Now, exceptions. You can have food consumed at a business meeting or a service or good received in connection with a trade fair or educational program. So again, if you come to those networking breakfast seminars that we do, you're allowed to eat. That's okay. It's not considered a kickback. You're allowed to, take our pens and stress balls. You're not gonna get in trouble for that. Now, important to know, if a director or officer is charged by information or indictment with any of the following crimes, they must be removed from office. This all makes sense. This all tracks. But it's important to know because now they've really codified these things. So immediate removal, forgery of a ballot envelope or a voting certificate, theft or embezzlement of the association's funds or property, tampering with physical evidence, obstruction of justice, any other criminal violation that we've now put into Chapter 720. So if a director or officer is charged by information or indictment, they're removed from office. So information or indictment essentially means some law enforcement agency has charged them. So the state attorney's office has pending charges against them. Doesn't mean it's a conviction. It means it's a charge. But also that doesn't mean just the board can decide that. That's something that would have been done by a, government agency. The board has to fill the vacancy till the end of that. But ultimately, if the charges are resolved, maybe it was all one big misunderstanding, the charges get dropped, great, that person can be reinstated for the rest of the term. Okay. If the criminal charge is still pending, that person can't be appointed or elected to a position as an officer or director of any association, can't have records or can't have access to official records of any association unless court orders that. Because again, we're very concerned now about HOA theft and making sure that doesn't happen again. All right. A director who becomes more than 90 days delinquent in the payment of any fine or monetary obligation is deemed to have abandoned his or her seat, and that creates a vacancy on the board, and the board can fill it. Important to know for this. So if you have a board member who falls behind, and it happens all the time, basically they have a little wiggle room. They have up to that 90 days, but more than 90 days, they are automatically off the board. The rest of the board can now fill that spot. And it doesn't mean if you tell that person, hey, you haven't paid and we're at, 95 days, they can show up and hand you a check and say, okay, I'm right back on the board. I paid you. I'm good. Nope. Board can fill that spot. Once they're off, it's a vacancy. They do not get to automatically come back on. If ultimately the board says, okay, well, Joe, great. We happy to take your money and we'll put you back on the board. No problem. That's one way you can go about it. But sometimes the rest of the board says, well, we really didn't like Joe anyway. We don't want him back on the board. Too bad. Conflict of interest disclosures. This is another topic that's kind of been hot in the news for the last couple of years. We're very worried about conflicts of interest. It all tracks with our overarching theme, guys. So again, we want to be very careful if there's any possible conflict of interest. If anyone is engaged in a service with the association, a director or an officer or their family member, or they have a business that they have an interest in that's contracted with the association, those are all things that could be considered a conflict. There is a process on how you can still go about it and how you can approve it and how you can still move forward. Because just because a director has an interest in maybe, again, a landscaping company, maybe it's the best landscaper in all of Broward County, and your vice president happens to have an interest in it, and you're looking for a new landscaper anyway. And he says, hey, listen, I'll make sure we get the best prices. I make sure our company does a great job, all of that. it also does make sense that he would want to have a, a nice landscaping company. He would also want to save that money. It doesn't mean that any wrongdoing is happening if you want to hire that company, but you have to follow the process and make sure you do it properly. Committees, be aware. Basically, there's again some information here for you guys. Official records, we'll get into that. Official records, and I'm not going to read these all to you. There's a couple slides basically listing everything that you need to keep as an official record. Hopefully you all know you should have all of these things. There's a whole long list here. Keep them, make sure you have them. They are your official records. The big catch-all here is any other written records of the association, but typically it's your governing documents, your contracts, all of that good stuff. Have that in your official records. Now, you have to maintain your official records generally for 7 years. Some of them now it's a little different. Bids you keep for 1 year. New law effective this year was you have to adopt written rules governing the method or policy by which your official records are going to be retained and the time period the records are going to be retained. And that information has to be on your website. So that was a new little wrinkle they added. Not really sure why. But ultimately, that's something you should have in place now. Talk to your management team, talk to your attorneys, just adopt a policy essentially mirroring the statute and saying you're going to adopt you're going to have these official records. You're going to keep them in line with the statute, all of that good stuff. Have a policy in place. There are official records that are not accessible to some members or to any members. And again, there's a whole long list. We won't get into too much of the detail, but the ones to be aware of: attorney-client privileged information, information you get in connection with a lease, sale, or transfer of a parcel. That's important because if you think about it, when you're running background checks, maybe if your community, reviews applications, you might be running background checks, credit checks on people, and you have a lot of their very sensitive information, let's say. That's not information that should be open to other owners. That makes sense to me. Most of this is pretty logical. Personal identifying information, passwords, things like that, not going to be open. Personnel records of your employees, medical records if you happen to have any. If you have owners who maybe had emotional support animals, maybe they gave you medical records to back up a request to have those animals. Those medical records have to be kept away and not open for owners to inspect. Attorney-client privilege, we went into that a little bit. Membership directories, we get that question. So can we have a directory? How does that work? You can print and distribute a directory with the name, the lot address, and the telephone numbers of each owner. But an owner should be able to basically opt out, exclude their telephone number if they want. And they could, if they wanted, they could provide written consent that you can disclose other information. Maybe they have multiple contact, addresses or whatever it is, or phone numbers. Providing rules and covenants. Hopefully you guys have already complied with this before October 1st. So we're what, 6-7 weeks after this deadline. The association is supposed to provide a physical or digital copy of their rules and covenants to every member. So hopefully, again, you've already done that. You've already complied with that. Otherwise, talk to your attorneys or management ASAP. Access to official records. So the whole point of, keeping all these official records, then also we have to make them available to our owners. Like we said, some are not going to be open for inspection. We already went through that list. How does it work? 10 business days after receipt of an owner's request, you can make an appointment, or now they've clarified, you can also make the records available via the internet or, through the website. If someone sends a records request and they want to see, hey, I wanted to see a copy of whatever it is, a copy of our rules or our bylaws or the minutes from 2 months ago, and that's information you already have on your website. That's why this whole website thing was supposed to be convenient. Now you can respond and say, go ahead, and that information, those documents that you're looking for are on our website and you've complied. Now, you want to make sure too, if your request is submitted certified mail, return receipt, again, that 10 business days, if you don't respond, you're going to be considered, it's a rebuttable presumption that you willfully failed to comply, and there could be actual damages, $50 per calendar day, up to 10 days. So be aware, you will have some owners who will just do records requests to try and, catch you, so to speak. So make sure if you think you have a records request, You talk to your attorneys, talk to management, and address it appropriately and timely. Another new change in the law here now, if you have, and I don't know why they had to specify this, but I guess this was an issue in some of these cases I've been talking about. If the association receives a subpoena for records from a law enforcement agency, the association must provide a copy of the records or make them available within 5 business days. You must assist a law enforcement agency in the investigation to the extent permissible by law. Like I said, you'll see a theme here. Official record crimes. New laws effective July 1st, 2024. This is the one we don't love, I'll be honest. This is the one I want you guys to be very careful about and be aware of. Any director who knowingly, willfully, and repeatedly, which is defined as 2 or more violations in a 12-month period, fails to provide access to the official records with the intent of causing harm, and again, I'm not entirely sure what that's supposed to mean, to one or more of its members, commits a second-degree misdemeanor. So now failing to provide records can be considered a crime. So we want you to be aware, because this is a little scary and a little intense in my opinion, but just be aware of this. Any person who knowingly, intentionally defaces or destroys accounting records with the intent of causing harm, that one I'm less bothered by. If you're going to destroy records, okay, fine. It commits a first-degree misdemeanor. Knowingly, willfully refuses to whatever it is, refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, punishment, or to assist another person with those things, commits a third-degree felony. Again, less concerned with that. If you're hiding records or, refusing to release them because you're essentially covering up a crime, I'm okay with that being a crime. I don't love the willfully fails to provide access with the intent of causing harm. That's a little not clear enough for my liking. All right, official records rules. You can adopt some rules, be aware, talk to your attorneys before you do that, because there are some guidelines. You can't require that an owner show a proper purpose or state any reason. You also have to allow at least an 8-hour window of time per month. Be aware of that.
Emily, let me just interject 1 second here, because I'm getting a lot of these questions. And while I'm doing that, check your phone real quick. Folks, if you drop off, if your technology boots you off, you have a drop in your internet or whatever it is, and you come back in, don't worry about it. Zoom shows with the timestamps that you got knocked out and that you made the effort to come back in. So we can see that on the report after the event. Emily, back to you.
All right, good. Thanks, guys. And like we said, there's 200 slides here. You're going to get them all at the end, so you can go through them. If you miss something, if you're gone for a minute, you can read through them at your leisure. Copying records and fees. If someone brings a portable scanner, or if they want to take their phone or even their iPad and just take a picture of a record, we do get that a lot, that owners will do that to get a copy instead of paying, the 25 cents or whatever it is. If they do that, it's free. They can use a personal scanner, they can use their phone, they can take a picture. You're not charging for them to do that. If you're using a copier, you can charge 25 cents per page. There is actually the ability to charge some personnel costs, but there's some limits there too. That has to be, only if they've copied 25 pages or more, and you're still limited, essentially can't exceed $20 an hour. We get that question all the time. These records inspections take so much time from our manager. Can we charge the owner for it? That's your answer. It's not great, and I'm sorry, but I didn't write it. So, all right, association website. We talked about a lot of this, or this has come up a couple times. 100 or more parcels, January 1st, have to have a website. You have to provide your owners with a username and password, because again, there should be protected portions of the website, not just open to everybody. Copy of the following documents, and there's a whole list of here, everything that needs to be on your website. Again, I'm going to skip through this. You can read through that at your leisure. A lot of information there. Amending your governing documents. Important to be aware, you're going to look at your governing documents to see what their provision is. If there's something in your declaration already, which there probably is, that's what you're going to follow if you're amending your declaration. If there's nothing, if you have old documents and they don't say anything about amending, you're going to need a 2/3 vote. 2/3 of your owners are going to have to approve any amendment. There is a certain format you have to follow when you're doing amendments. You have to strike out what you're taking out and underline what you're adding. There is a way to do it where if you're changing a whole section and that's just too much, you can indicate it's a substantial rewording, all of that. But generally, you can't just say, oh, here's, the new Article 2. It has to have that, we're taking this out, we're adding this, so people can follow and follow along. Lender consent, it's important to be aware of that. There's language in a lot of these governing documents that if you are going to amend your governing documents and it impacts a lender or, the mortgagee, when they lent out that money, they are supposed to get a say in that too, if you're impacting their rights. Now, there is a statute that says basically you can do a mail out, and it's if they don't respond within a certain amount of time, it's considered that they've consented. So be aware of that if you're thinking about doing any amendments. An amendment is going to be effective when it's recorded. So also important to know, because we hear that sometimes, that the members will have a meeting, they have the, the vote comes in, board affirms, okay, the vote passed, we have our new Article 3 or whatever it is. Okay, well, we have to record that, otherwise it's not effective yet. You can't just say, well, the meeting was last night and we've adopted, new criteria for reviewing sales, and we have a sale application happening right now, so can we apply that? Well, it has to be effective when recorded. Also important to know, you have to send a copy to your owners once it's actually approved. Now, or after it's recorded, I guess I should say. A copy of the proposed amendment, if it was sent out to everybody beforehand and nothing ultimately changed with it, it's the same, as proposed that was adopted. You don't need to send it again, but you have to send notice that at least it passed so people are aware and put on notice of the new change. Leasing restrictions. There were some changes now a couple years ago, July of 2021. I have no concept of when that was anymore. I was going to say I couldn't remember if it was before or after COVID, but July of 2021, this is the new world for us. Before that, you could adopt amendments involving leasing. You could put in new restrictions. You could take out all leasing if you wanted, and it would apply to everybody. There was no question. There is already a restriction in Chapter 718 in the condominium world that says, it has sort of a statutory grandfathering. So now the compromise was in 2021, we put a similar provision into Chapter 720 of Florida statutes. So now, if you are going to do a leasing restriction, if you're going to amend to add a leasing restriction, you have to be aware of this. It may only apply, depending on what it is, it may only apply to those who take title after the effective date, or an owner who agrees and who consents to the amendment. Now, there are some exceptions. So if it's an amendment where you're prohibiting rental agreements for a term of less than 6 months, or prohibiting rentals of more than 3 times in a calendar year, those will apply to everybody. But any other sort of leasing restriction that you're trying to regulate rental agreements, it's only going to apply to those who agree to the amendment or who take title after. So you may have some owners who ultimately get grandfathered in. Just be aware, that's very important. It's been a hot topic the last couple of years. All right, we won't get into too much of this detail. All right, this is sort of a miscellaneous topic here. Few gems that you should all know. And again, we won't go through all of these line by line. So here are our topics, and we'll hit the highlights. Government filings. To maintain an active corporate status, make sure you guys file your annual report with sunbiz.org, pay your filing fee, get that done. You might have to do a tax return, check with your accountants, all that good stuff. Meeting minutes. Any meeting, you're supposed to take some minutes. Minutes don't necessarily have to be a full script of everything that happened. Joe said XYZ. Mary said blah, blah, blah. You don't have to do that. It's just, Joe made a motion to do blah, seconded by Mary. All in favor? Everyone was unanimous, whatever it is. Keep just those highlights. So what your motions are, who voted, and who, if anybody abstained, that's what you need in your minutes. Who was there, all of that. not a verbatim recount of every sentence that was spoken during your meeting. Material alterations, this is something that doesn't typically come up in the world of HOAs. This is more of an HO or a condominium item. But, and this is why there's a condominium case that defines what a material alteration is. But basically the question is, can the board change something, change, the common areas without a membership vote, or do they need a membership vote to approve it? Now, look at your governing documents, see what they say, see what the story is. Often in the world of HOAs, there's sort of a financial threshold. If the association plans to spend, if the board's going to spend 10% of the budget for a project, they need membership approval or whatever it is. And that may be the case. If you plan on just leveling your clubhouse and putting in a, basketball court, it might be a significant project. There might be a reason to have a membership vote, but maybe not. Depends on what's in your governing documents there. Rules and regulations, you want to be aware of, the association can adopt rules, but see what your authority is. See if you have authority to adopt rules about lot use, or if it's just about common area use. See what the deal is there. That's all something that would be in your governing documents. See if it requires any membership approval. Sometimes there's language in your governing documents that even a board rule requires members to approve it. Typically, no. Typically, it's just board, but check your governing documents, see what the story is there. Marketable Record Title Act, also known as MRTA or MARTA. You'll hear that a lot. If you're in an HOA, you need to be aware that your covenants expire after 30 years. So there's a whole question about when that is, depends on the root of title for your lot, but guideline generally is when was your declaration recorded, and are we within that 30 years? Are we outside that 30 years? Have we preserved the covenants? There's a process to preserve your covenants. That's really just a board vote. That's easy to do. If we're outside of the 30 years and your declaration is possibly, your covenants have expired, then we might have to revitalize the covenants and revitalize your declaration. That's another process. It requires your members to vote, and it requires a majority of the members to vote and to approve it. So something to just look at, see how old your documents are, make sure they haven't expired. If you're over 30 years, see if they were preserved. There would be a notice, it would be recorded. You would have some information on it. Look at that and make sure you can still enforce your covenants. Process servers, bottom line, you have to let a process server into the community. Community association management, there's certain requirements here of basically what qualifies to be a CAM and when you need a CAM involved. Emergency powers, we're not going to get too much into this. This was something obviously they expanded again during COVID. The association has some emergency powers. If we're in a state of emergency, some things they are able to do. There's a whole list there. Again, read them at your leisure. Driver's licenses, odd, but you guys should be aware that there's something involved here with you guys in driver's licenses. It's unlawful for private entities to swipe the driver's license unless they have the consent to do it. So be aware. If you had an old process where, owners would have to swipe at the gate, don't do that anymore. Debit cards. Association officers and directors are not supposed to use debit cards that are in the name of the association. So that's a no-no. Don't use the debit card, for your green HOA or whatever it is. If you do use a debit card and it's for an expense that's not a lawful obligation of the association, which would mean that it had been pre-approved by the board, which is reflected in the meeting minutes or in the budget. If you use the debit card and it's not for that lawful obligation, now we're stepping into the world of a crime, basically, because now they consider that a theft. Deposits, there's some language here. Again, we're not going to get into all of this stuff. Litigation authority, if you're an HOA and you're considering a big lawsuit where the amount in controversy is in excess of $100,000, you're going to need the vote of a majority of your voting interest. Be aware. And that's as long as you're at a meeting at which quorum is obtained. So if the board is considering a significant lawsuit, talk to your attorneys, make sure if you need membership approval before the board goes ahead and does that. Architectural control. This was another sort of newish hot topic. ARC guidelines, that's been pretty standard for a long time now, right? We tell you all the time, you should have guidelines adopted. You have to have criteria adopted if your declaration already says that the board has approval or has the ability to create a committee to approve certain changes, alterations to a lot, to the home, whatever it is, then you should have criteria in place. That's because you can't say no, essentially, if someone follows your guidelines and your standards. But if they don't know what those are, then that makes it a little too difficult. Excuse me. So you have to have these guidelines and standards already established, already adopted. As of July 1st, this was now, again, put in here where they really want us to know what the guidelines and standards are. So you have to apply them equitably. And it specifically now says if the association denies an owner's request or an application for construction of a structure or an improvement on a parcel, the association now has to provide written notice to the owner stating with specificity the rule or covenant on which they've relied to deny that request and the specific aspect that doesn't conform with the rule. So if you already have guidelines clear as day that say, the only paint colors we approve are, whatever, Sherwin-Williams 1, 2, 3 and Sherwin-Williams 4, 5, 6. Those are the only exterior paint colors we'll approve. And someone applies and wants to use Benjamin Moore, 2B. Then you can say, well, we relied on it because this is our criteria. We only allow Sherwin-Williams 1, 2, 3 and 4, 5, 6. And that's a Benjamin Moore, 2B. That's nice and clear and easy, hopefully. Or you have criteria, only shadow box wood fences that don't exceed 5 feet, and someone applies to do a white PVC 6-foot fence. That's very clear, nice and easy. If you only have a rule that says, we only allow 5-foot fences, but doesn't say anything about what color, what type, whatever it is, and the person wants a PVC fence, but everyone else has wood fences, but your criteria doesn't say they have to be wood fences, are you going to be in trouble if you deny it? Maybe. Important things to be aware of. All right. And then now there's possible, damages involved. Now, be aware. Now there's some changes in terms of what you can deny, what you can't deny, what you have the authority to review. If there's application for plans and specifications for AC, refrigeration, heating, that kind of thing, but it's not visible from the parcel's frontage or an adjacent parcel or an adjacent common area or a golf course, not going to be able to enforce the covenant that requires that review. That one kind of makes sense, but we'll get into this in the one that I find a little strange. That's this one. Items on a parcel. So regardless of any covenant you have, so if your deck says, the clearest example is, no artificial turf, whatever, maybe. And you have a covenant, says it in your declaration, no artificial turf. All right, great. And an owner says, I want to replace my backyard. I'm ripping out all the sod and I'm going to put in an artificial turf. You'd probably say, well, our covenant says no artificial turf, so we can say no, right? Well, maybe, maybe not. Now the statute says, regardless of any covenant, you can't restrict owners from installing, displaying, or storing any items on a parcel which are not visible from the frontage or an adjacent parcel, an adjacent common area, or a golf course, including but not limited to artificial turf, boats, flags, vegetable gardens, clotheslines, and recreational vehicles. That's a big one. People want to put RVs in their backyards. People want to put boats in their backyards. And you might have a provision that says, nope, you can't keep those things in your backyard. Well, guess what? If you can't see it from adjacent parcel or from the front of the parcel or from anywhere else around, essentially, you might now be able to not enforce that provision. That covenant might not be enforceable. That's what the statute now says. Now, we're going to circle back real quick. And I was pretty dead on. I thought it was about slide 100. Kaufman language. When I said that earlier, Kaufman language is very important with this analysis. If you have Kaufman language, the statute now says you're limited and you can't enforce these covenants. That would mean if you have Kaufman language, that's what the statute says. You're following the statute. You are now restricted. This is what the statute says. You can't enforce anymore. But there's an argument. If you don't have Kaufman language, now, was our covenant that we couldn't have artificial turf or boats or RVs in the backyards, all of that? maybe that's considered a substantive right. And maybe that's something that now if the statute changed, but we don't have Kaufman language, we're going to say you can't impair that contract, that declaration, that covenant that we already had, and we should be able to enforce our covenant. And we're basically going to ignore the statute because we're going to enforce our covenants. Again, there's a whole legal argument. That's what you need to be aware of. It comes up in a couple slides for something else as well. But as silly as it sounds, this is actually really a big enforcement issue we've had to deal with in the last couple of years. Flags, be aware, even if you have a covenant about flags, statute's going to say you have to allow some certain flags, certain flag poles. They did modify it and expanded what flags you're allowed to have. Now a first responder flag, law enforcement, firefighters, paramedics, they expanded that this year. Hurricane Protection Association must adopt hurricane protection specifications for each structure, governed by the association. So you should have, again, ARC type guidelines for roofing, hurricane shutters, and then there's a whole bunch of other stuff that's part of hurricane protection. Vehicle restrictions. This is the one. It is slide 100. I was, look at that. I was right. All right. This is another one where the Kaufman language comes into play. An owner, the statute now says that the association can't prohibit an owner or a tenant or a guest from parking his or her personal vehicle, including a pickup truck, in the owner's driveway or anywhere else that they're allowed. Typically, they have a right to park, basically. Now this comes up. Okay, but wait a minute. We don't allow trucks in our community. So can we still enforce our truck restriction because our declaration says no pickup trucks? Or does this statute now trump that because the statute says you can't prohibit people from parking their personal vehicle, even a pickup truck, in their driveway? We're back to the Kaufman argument. You have to talk to your attorneys, see what the deal is. You may have to follow the statute. You may not. Maybe there is a legal argument there. Talk to your attorneys. Part of this is also work vehicle. So if you have an owner who has a vehicle with official insignia, visible designation, so maybe it's a wrapped car, which typically you would say, oh, it's a commercial vehicle. We don't allow those either. Same argument's going to come up. It can't be a commercial motor vehicle that falls into that specific statute, 320.01, which is basically like an 18-wheeler. That's its own monster, so to speak. But that's another important thing that has come up recently. All right. Contractor restrictions. You can't prohibit an owner from allowing their contractor to come into the community solely because that contractor is not on the preferred vendor list. You can't prohibit them just because they don't have their professional or occupational license. Same thing. That was a new change. Budget and reserves. We are going to speed through the second half of this. I swear, guys, we'll get it. We'll get it done. All right. It is about budget time. So hopefully this is not news to you guys. You have your budgets hopefully done. Annual budget is supposed to be your basically a good faith estimate. So we tell you, look at last year's actual expenses and then adjust accordingly. Budgets have two components, your operating expenses and your reserves. And in the world of HOAs, reserves are a maybe, not a must necessarily. It's a maybe, depending on, not all HOAs have reserves, not all HOAs are required to, and we'll get into the designation here a little bit. Operating expenses, you guys know what that is. It's basically your normal everyday expenses, your management fees, your insurance, your taxes, all of that good stuff. All right, so do you have to have reserves? You may or may not have reserves. What would you have reserves for? Those are for those, long-term projects, the stuff that doesn't necessarily need to be repaired in a year, paving, sidewalks, things like that. Your reserves essentially could be created two different ways. Your developer might have put in the documents that you have to have reserves. Now you have developer created reserves. The other option is membership created reserves. Now that doesn't mean that, a slush fund or something that the board decided, okay, we're going to keep a fund for, a possible sidewalk project. If the board decided that, you're not obligated to fund it. But if a majority of your total voting interests approved creating that reserve account or that reserve item, now you do have to fund that. So be aware if it's developer created or membership created. Now you're stuck and that's a reserve account you're going to have to fund. Otherwise, like we said here, this last line, created any other way, it's not going to be subject to the restrictions that are in the statute. And again, maybe the board called it a reserve, but it really wasn't a reserve. You know, you have to take a look at how it was done. Calculating your reserves, pretty easy. Get a reserve study done. You're going to know, you know, the total estimated useful life, the remaining life. You do the math, you figure out what you need to, you know, account for each year. If you want to change the use of reserve funds, or if you want to pool your funds, you can do that, but you need a membership vote. To waive, reduce, or terminate reserves, again, you're going to need a membership vote. Notice an adoption of your budget. We've had this question come up a lot. And again, this is another one of those weird differences between HOAs and condos. Condos, there's a specific notice requirement. HOAs, you don't have one in the statute. So for the board to adopt the budget, unless there's something different in your governing documents, it's just a board meeting. It's a 48-hour notice. All right. So unless your governing documents say something different, maybe it is subject to membership approval, but that would be something in your governing documents. The budget is typically adopted by the board, and it is done at a board meeting, duly noticed, 48 hours. Okay. That confuses people for some reason. Association with 100 or more parcels, by January 1st, you're going to have to post a copy of that proposed annual budget on your website. All right. Okay. This is the other thing we say. Technically, the statute does not say you have to send a copy of that proposed budget out to everybody before you adopt it, but we would suggest you do so that your owners, you know, are not too mad at you. Once it's adopted, then you have to send a copy of the budget or written notice that a copy is available to everybody. Okay. Assessments and foreclosures. And there are a lot of slides on this because we teach a whole class that's, I can't remember if it's an hour or two on just basically assessments and foreclosures. So I'm going to end up skipping through a bunch of slides, but I'll give you the gist. Special assessments. If you're going to consider a special assessment, there is specific notice requirements. It's going to be done at a board meeting typically. It has to be mailed, delivered, electronically transmitted, posted on the property 14 days before. So that's one of the exceptions. Normal board meetings are 48 hours. Special assessment meeting, 14 days before. And that is hard and fast, guys. That is a real rule that you have to follow or you're going to have an issue collecting that special. So make sure you follow it. A notice of the meeting has to include a statement that the special assessment is going to be considered, the nature of the assessment, and the estimated cost of the assessment. So if you just post a notice that says special assessment meeting and your agenda item is consider special assessment, that's not going to cut it. Special assessment meeting to consider a special assessment in the approximate amount of $100,000 to replace the clubhouse roof. You know, you have to have the amount in there and the purpose. Once it's levied, you have to send a written notice to all of your owners, give them a reasonable period of time to pay the special assessment. You could do it, you know, in installments. You could do it in one fell swoop. It's up to you as the board to make that decision and make that clear in your motion at the meeting. And if it's not paid by an owner by the due date, it's collected in the same manner as a regular assessment would be. So if an owner doesn't pay the special and for whatever reason, they just, you know, decide, well, I don't use the pool, so I don't care that you needed that money for the pool, so I'm not paying the special assessment. Okay, well, you can still treat it as a regular assessment, send them to collections, foreclose, all of that. Now, there's a question here at the bottom. If membership approval is required but cannot be obtained, what is the board to do? So this is an important thing. If you have a special assessment that you're adopting essentially because, and typically a special assessment is to, you know, deal with something that was not budgeted for, maybe a sudden cost, an overage, maybe your insurance went, you know, skyrocketed this year and you really didn't expect that because, you know, for the clubhouse or whatever it is. Typically special assessments, you know, or for those unforeseen expenses. Now, if membership approval is required, sometimes the governing documents will say that, or it'll say something along the lines of if the board is adopting a special and, you know, in more than X dollars, it requires membership approval. The big thing to be aware of is what is the special assessment for? There is case law that says if it is for a necessary repair, something like that, if you are fixing the clubhouse roof because there's been a leak, then membership approval is not going to be required anymore. Now that case law kicks in to say it's a necessary repair item. It is a necessary maintenance. We have to fund it. So this actually makes sense. Board has to do the repair. You have to fund it. You have to be able to adopt that special. The special is still going to be good, even if the board, even if the membership wouldn't approve it otherwise. All right, this was a change to the statute again this year. Normally 720 doesn't get a lot of changes, but this year you guys got a lot. So lots of new stuff. Parcel owner can make a written request to the board for a detailed accounting of any amounts he or she owes to the association. And the board must provide such information within 15 business days after receipt of the request. Okay. And then that person can't request another one for at least another 90 calendar days. If the board doesn't respond within that time, it's a complete waiver of any outstanding fines, which are more than 30 days past due, and for which the association has not given prior written notice of the imposition of the fines. It's sort of a weird penalty, but they didn't want you to, waive all amounts due. So here we are. All right, we're going to skip some of these, like I said. Interest and late fees. Hopefully you guys know you're entitled to collect interest and late fees for your collections efforts if someone doesn't pay an assessment. Look at your governing documents, because essentially they're gonna dictate whether you can charge interest and late fees and what those rates are. And the statute basically kicks in if there is nothing there. And you can also incur attorney's fees and costs and recover those as well. And we'll get into the nitty-gritty of that. Application of payments. Essentially, if someone has a delinquent balance and they make a partial payment, for example, the statute actually outlines how that payment gets applied and where it goes. You can't just say, well, but that check I gave you was for, November's maintenance, so I've paid November's maintenance. No, if you have an outstanding balance, that is going to go to interest first, then the late fees, then the attorney's fees, then that finally to that last delinquent assessment. So if they're running a balance, sometimes the owners get a little confused when they're delinquent, but that's how the application of payment works for them. All right. And that's, again, regardless of any restrictive endorsement. If they say that's, that was my November payment, so you can only apply it from my November maintenance, not necessarily the case. Notice of late assessment. This was something that kicked in, I think, maybe 3 years ago as well, 2 or 3 years ago. Again, no concept of time anymore. This is an extra step that now the association has to follow before they can turn a file over for collections. So for our purposes, we don't want the file to come to us for collections unless the association has already sent this notice of late assessment out. It is a statutory notice. It gives the owner sort of the last chance, 30 days, and you have to follow a certain format that's outlined by the statute that gives them exact breakdown of when the due dates were, what's owed, and they have 30 days to pay it, and has to be sent to their lot and their mailing address. And it needs an affidavit to, basically demonstrate that that's how it was mailed out. And at that point, you can't collect any attorney's fees. So that's why we say, you guys send it, have the management team send it before the file comes to us, because we don't want to incur any attorney's fees for you until, that's been sent, because you're not going to get those fees back if an attorney does it for you. Next step, once it gets turned over to us, so you've sent your notice of late assessment. Sometimes you hear us kind of call that the NOLA. Once that's sent by management or by, the board directly, 30 days, they have 30 days to pay. Great. Let's say they don't pay, send it over to your attorney. Attorney has to send a lien letter that says, we are going to record a claim of lien against your property. That secures any unpaid assessments, interest, late fees, attorney's fees, all that good stuff. 40 days, it's a notice, 45 days, notice of intent to file a claim of lien before we can actually file the claim of lien. Okay. Then we file the claim of lien. If they're still not paying, we send a second letter, another 45-day notice, where we say, great, hey, guess what? We filed this claim of lien. Now we're going to foreclose it. You have 45 days to pay the outstanding balance. So it's notice of late assessment is 30 days. That's the notice that goes from your management team. Then the attorneys are going to send 2 notices, statute requires, lien and foreclose, before it can go to foreclosure. All right, first mortgagee assessment liability. Let's look at this really quickly. If an association wants to foreclose, one of the big factors is going to be Is the lender already foreclosing? Maybe we just sit back, we wait for the lender to do their foreclosure, and we'll see what we get. You need to be aware you might not get much. If the association is just waiting for the bank forecloses and they are a first mortgage, there is safe harbor provision in the statute. So again, if the first mortgagee initially joined the association as a defendant, so they named the association as a defendant, and they were foreclosing on this property, and they ultimately take title, the association is only going to recover from, Bank of America or whatever it is, the lesser of 12 months of assessments or 1% of that original mortgage debt. So it's not a lot. You're not going to get, your outstanding balance that goes back 3 years necessarily. All right, so be aware. We don't have to get into this. We'll skip a couple of these things. A third party bidder. So again, this comes up if, again, maybe there's a bank foreclosure, Bank of America is foreclosing, but, investors 1, 2, 3 decide to buy the property. Now, what does investors 1, 2, 3 owe the association? That's a good question. They might get the same benefit that the lender would have had, but we want to look at that interest or look at that language in your governing documents and find out. All right. This is the part, this really gets into sort of the weeds of lender foreclosure. We don't need to get into it. Essentially, there's a way to sort of try and move the lender's foreclosure along. That would be in order to show cause. Collecting rent, this one actually, I guess I should go back to. There is a statute that addresses tenants and tenant rental payments. This is important to be aware of too, because this might be another good tool for you guys. If an owner has his unit or has, in this case, their lot rented, but they're not paying you, they owe you money, and they have a tenant's paying, well, guess what? The statute actually lets you send a demand letter to that tenant and tell the tenant, hey, start paying us, the association, because your landlord's delinquent, and we'll tell you when to stop. Just keep paying us your rental payments, please. And the statute protects them. They're immune from claims. They can't be evicted just because, they're not paying their landlord anymore. But that's a good tool to have in your arsenal if you have any delinquent homeowners who are maybe investors or, again, renting out their homes, then have the tenant start paying you instead, and you can maybe get your money back that way. Financial reports, we talked about the budget. This is sort of, along those same lines. Statute requires certain financial reporting. Talk to your management team, talk to your accountants, make sure you're complying. There's thresholds here of certain, your total annual revenue and what level of financial reporting you're supposed to be doing. You can raise the level of financial reporting. That's a membership vote. You can lower the level of financial reporting. That's a membership vote as well. Be aware, they changed this, they tweaked this a little bit this year. You can't prepare a financial statement of a lower reporting level, for consecutive fiscal years. So again, when we're worried about where association money is going and making sure our boards are doing things properly and being transparent, now we want to make sure, we're not reducing that reporting level for consecutive years. There are certain disclosures that have to be contained in your financial reports. This is that language. Contracts and bids, we'll get into this a little bit. We're attorneys. So the gist is, it says contract that cannot be fully performed within 1 year for the purchase or lease of materials or equipment. And if it's a service type contract, those are all supposed to be in writing. But like I said, we're attorneys. We're going to tell you any contract you have should be in writing. Seems simple enough, but you wouldn't believe the stories we hear. Now, any written contracts should specify the obligations of the parties. Again, that seems simple, but sometimes that's where people get, confused. Hey, they said they were going to cut our grass twice a month. Well, is that in the contract? Or does it just say regular, cuts? Make sure these are things you're actually looking at. The cost for the services, the frequency of the services. These are the things, again, you'll end up arguing about down the road. Make sure your contract addresses all these things. Bids, if the aggregate cost of a contract is more than 10% of the total annual budget, which includes reserves, then you have to obtain competitive bids. You don't actually have to accept the lowest bid. I know that's sort of a common misunderstanding there. There might be a reason you don't want to. Maybe you've done a little, research on these guys and You know, the guy who gave you the lowest bid just doesn't sit right with you, or you heard sort of a weird story and the guy a little bit more expensive just won you over a little bit more. That's fine. Doesn't mean you're doing anything wrong if you don't pick the lowest bid. Again, reasonable business judgment rule is going to protect you guys individually as board members. So if you have a good reason, if it's logical, reasonable, all of that, you're going to be safe, you're going to be protected, as long as you're not, you know, taking kickbacks and all that. All right. Certain contracts are going to be exempt from the bidding requirements. Any employees, accountants, attorneys, sort of your professionals, so to speak. All those contracts should still be in writing. All right. Communication services, there's language in here basically about, you know, cable, all of that kind of thing. Those contracts, typically bulk communication, internet, are deemed an operating expense that are allocated on a per lot basis. So not percentage wise, even if your assessments otherwise would be percentage. Be aware of that. It's if you're going to change that, there's language in here. You can cancel that vote by majority vote if that was again, look into that if that's something that you guys are interested in. We don't need to get too far into that. Transfer fees and estoppel certificates. Again, we're going to sort of fly through this as well. Transfer fees, important to know, basically, you know, transfer fees are not looked upon favorably. And in the world of, and I know I said I wouldn't talk about condos a lot, but in the world of condos, 718 has certain restrictions on what transfer fees you can have. 720 doesn't have that. So that's why you'll see transfer fee, you know, a lot of the times in the world of 720 in HOAs, there'll be, you know, maybe capital contributions upon any purchase, that sort of thing. And that could be, you know, 2 months worth of assessments, or maybe $500 up to $10,000, you know, sort of capital contribution, whatever it is. There's nothing in the statute that prohibits that, but that would be something that would have to be in your governing documents. And, you know, you'd have to check for that. Estoppel certificates, that is basically, you know, kind of your payoff as part of a transfer. So again, we won't get into the weeds with your estoppels, but be aware there's a time frame. If you get an estoppel request, you have 10 business days to issue the certificate. Here's all the contents. Again, lots of slides on this as well that we don't need to get into too much here, guys. All right. Covenant enforcement. We have a whole class on this too that I could talk about covenant enforcement for 2 hours, but we're already almost at 2 hours, so we're going to speed through a little bit. The gist is that you need to know is, as board members, you have a fiduciary obligation. You are supposed to be enforcing your governing documents. I know you want to be nice. I know you like your neighbors. You don't want to be the bad guy, but you are supposed to enforce your governing documents. That is part of the job. That means these covenants, you are supposed to be enforcing them. That can include architectural standards, pet restrictions, nuisance restrictions, parking, all that good stuff. If you don't properly enforce them, and then that means timely and in a uniform manner, if you don't properly enforce them, you run into problems down the road where you can't enforce them without certain action, because now you've waived the ability to do so. Or you run into an argument about selective enforcement, which could be a successful affirmative defense as well. You know, you told Mary she couldn't have her truck in the parking lot, but you let Joe park his truck in the parking lot, whatever it is. That's a selective enforcement issue. You could have all these problems. Let's get into it a little bit. Ultimately, you have a couple tools in your tool belt on how to enforce a restriction, how to enforce a covenant. You typically just start with sending them a letter and say, hey, Article 10 says no trucks, or, you know, Article 9 says you can't have whatever, you know, you're not allowed to have 4 dogs in the community. So we've seen you with 4 dogs. What's the deal? And give them an opportunity to cure it. Okay, has to go. Or, you know, the motorcycle has to go. The truck needs to be parked in the driveway or can't be parked overnight. All of these variations. Tell them what the violation is and how to fix it. And if they don't, here are some tools we have. You can fine. You can suspend use rights. Now, a fine or a use right suspension can't be imposed unless the board first acts. The board has to levy the fine or the use right suspension at a properly noticed board meeting. So the board decides first, okay, we've decided that Mr. Smith is in violation of our governing documents. He has, you know, whatever violation, he's parked on the swale for 10 days straight, $100 a day, up to $1,000. Board's going to levy a fine of $1,000. Okay. Now you have to give that violating party a 14-day notice that there's going to be a hearing in front of a committee. All right. That committee has to, that hearing's going to be within 90 days. All of these timeframes are very important. 14 days. Now within 90 days, you're having this hearing. Who's on that committee? 3 members appointed by the board. They cannot be a whole bunch of people. So finding people to serve on your finding committee is not easy. I get it. It can't be officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee. It's a lot of people who cannot be on your finding committee. So like I said, finding people to actually serve on your finding committee is difficult. And obviously it's because then they're the people who have to give the bad news to their neighbors. So most people don't really want to do it. But here we are, but it is one of the options. Within 7 days after the hearing, the committee has to mail or email a written notice to the violating party of the committee's findings. They have to include any fine that was actually, you know, confirmed or imposed, and or suspension, and then let the person know how the violation can be cured and a date by which the fine must be paid. If the violation is cured before the meeting, or before the hearing, I should say, the fine cannot be imposed. So if you send somebody a notice, if the board decides, you know, Joe has had this truck in the driveway for 10 days, we're going to fine him $1,000, we're sending him the hearing notice. Great. Truck hasn't moved. Eve of the hearing, truck's gone. Now what? And we get into lots of questions. Well, was it cured? It wasn't cured because it was there and now it's not. Is that a cure? Lots of sort of gray area with these things. So talk to your attorneys when we're talking about fining. It can be it sounds silly, but it can be a little complicated and a little messy because if you don't follow the procedure correctly, you're not going to be able to enforce your fines. Another thing to be aware of, that the attorney's fees and costs can't be awarded against that parcel owner before the date set for the fine to be paid. So really, you want to make sure you're following a procedure and you're doing it properly before you get your attorneys involved, because you're not going to be able to get any attorney's fees up to that point. Be aware. All right. A fine, like we said, cannot exceed $100 per violation. And then again, it can accrue up to $1,000 per violation if it's, you know, on over time. Unless, and you guys actually in the world of HOAs are kind of lucky because you get a little advantage. Condominium, you can't lien for a fine, but HOAs, you might be able to. If there's language in your governing documents, you might be able to go above $1,000 for a fine, and you might be able to lien for it, and you might be able to foreclose for it. But that language has to be in your declaration. So make sure if you're thinking about doing any amendments, that might be something you might want to add some more teeth to your fine process or your fining procedure. You might want to be able to do that. When we're talking about use right suspensions, we're talking about the right to use the common areas. Typically that means turning off the clicker, turning off the transponder so that the people can't, you know, come through the resident gate. They have to stop at the visitor gate, or they can't go into the clubhouse. They can't use the gym. Now, you can't prohibit an owner from coming into the community or from parking. That's silly. That would be a little crazy. So they have to be able to use the other lane, or they have to stop at the guard and, you know, talk to the guard every time or whatever it is. That does drive people crazy. They don't love when they have to do that, but you can't stop them from coming in altogether. All right. All right. This was a new change this year as well. This is a oddly specific change to the statute, in my opinion, but okay. Apparently we're very concerned about garbage cans and holiday decorations. Who knew? All right, association. This was a change to the statute. So again, maybe there's a Kaufman argument. Maybe there's a legal argument if you want to talk to your attorneys before you do anything with this information. Association may not levy a fine for any of the following: leaving garbage receptacles at the curb or the end of the driveway within 24 hours before and after the designated garbage collection day or time. I will tell you, I have a community that is, they're townhomes. They are an HOA, but they are townhomes. And they are, because of that, they're, you know, close together. They don't have big lots, and they have 2 days of garbage collection pickup, you know, during the week. So essentially they asked, well, wait a minute, if it's 24 hours before and 24 hours after, and we have 2 days of garbage pickup, that means people can basically leave their garbage cans 6 days out of the week at the end of the driveway. That's not very convenient, and it's not very, aesthetically pleasing. And it is very annoying in a townhouse community where there's not a lot of room, for people. But here we are. That's what the statute says now. Leaving holiday decorations or lights on a structure or other improvement on a parcel longer than indicated in the governing documents. Can't levy a fine for that unless the decorations or lights are left up for longer than 1 week after the association provides written notice of the violation to the parcel owner. Okay, so a lot of these things have gotten a lot more owner friendly, we'll say, which again is frustrating a lot of my boards. But again, I didn't do these, so just don't shoot the messenger, guys. Use right suspensions. An association may suspend an owner's right to use common area facilities if the owner is more than 90 days delinquent in any monetary obligation, but that has to be decided at a properly noticed board meeting. So sometimes we have clients that put on every agenda, consideration of use right suspensions, and anyone who's over 90 days delinquent, that at that time, they'll make a motion to suspend their use rights, and then they send them a notice that it was suspended, all of that. Again, same thing we talked about. You can't keep them from accessing the community, but you can turn off that transponder, turn off the clicker so that they have to go through the visitor gate. They have to stop at the guard or whatever it is. I did have an owner, back years ago when I did some foreclosure work, that he called and he basically said, what kind of payment plan do I need? How do I fix the delinquency? How do I get you guys to turn my transponder back on? Because my wife and teenage daughter will kill me if they have to go through the guard gate and stop and talk to the guard one more time. So again, sometimes it's an effective tool. Once that payment is made, once that delinquency is cured, the suspension's over, they get their transponder or clicker or whatever it is reactivated. Voting suspension, this is another one. This is another tool you have in your tool belt, so to speak. If an owner is more than 90 days delinquent in a monetary obligation, you could suspend voting rights, but there was some, you should be aware, there was some case law recently that now there's a Kaufman discussion. Is it a substantive right? So before you suspend any voting rights, talk to your attorneys, make sure you're doing it properly, get the advice of your experts. Mandatory pre-suit mediation. If there's disputes between the association and an owner, typically those disputes are going to go to pre-suit mediation. Now, that is not all of them are going to go through that, but a lot of them will. Covenant enforcement, when we're talking about those violations, things like that, access to records, all of that goes through pre-suit mediation, where essentially one party is going to send a demand that we can't resolve this, so let's go to mediation. Let's talk to a third party, mediator, and see if we can come to some sort of settlement here. The idea was this keeps sort of our litigation to a minimum and it keeps costs down for the association, but not necessarily the case, but here we are. So you have to go through pre-suit mediation for these disputes. Some of them you don't. Some items you go straight to court. That is, if we're talking about collecting assessments, that's something you go straight to court. We don't have to worry about going through mediation. Some other things here, evicting or removal of a tenant or an occupant. Another one to be aware of if we're talking about recall or election disputes, that doesn't necessarily go right to court. There's a little, that goes through the division, but there's a little asterisk there because you might be able to just go straight to court on that. Pre-suit mediation. Before being able to file a lawsuit, the aggrieved party must first send this written demand that they're demanding the pre-suit mediation. There's a certain form that they have to use. The responding party basically has 20 days to pick a mediator, pick one of the mediators that was provided and agree to the mediation. Mediation has to be within 90 days of the demand unless it's extended by the parties. The parties share the cost of the pre-suit mediation, the mediator, essentially. All right. If there's an impasse, so if the parties can't come to some resolution, so again, maybe you do, maybe Joe decides, okay, I'll start parking my truck in the driveway. I'll stop parking it or I'll park my truck in the garage. I won't park it in the driveway, or I'll remove the truck from the community forever and ever until the end of time. You could get an order that says that, or an agreement that says that, and you might have to get an order from a court down the road to enforce it. But ultimately, if there's an impasse, that means a couple different things could have happened. You just couldn't agree, just couldn't get to any sort of resolution, or you couldn't agree on a mediator, or one of the parties doesn't show up. A lot of things can happen to get you to an impasse. Now, important to know, prevailing party attorney's fees. If you're going to pursue litigation, if you didn't participate in the pre-suit mediation when you were supposed to, your punishment, so to speak, is you're not going to be able to recover your attorney's fees if you're successful in the lawsuit. So be aware. That's why anytime you get a pre-suit mediation demand from an owner, because the association could be on the receiving end of that demand too. If you get a pre-suit mediation demand from an owner, reach out to your attorneys immediately, make sure you're responding to it timely, and you're, doing the things you're supposed to do, because you don't want to be penalized for not participating. And then possibly if you end up in litigation, you don't get your fees. All right. Self-help. This is important to be aware of. This was something that now has changed in the last couple of years as well. Before, if we had an issue where maybe, the maintenance requirement says you have to keep your lot in good and safe condition, and there's an owner who won't weed his yard. Okay. And that yard looks terrible. It's overgrown, patches of sod are dying. It looks, horrible. All the neighbors are complaining. You send a notice, you say, hey, Mr. Smith, you have to keep your yard in good and safe condition, and you're not properly maintaining it. We need you to weed. We need you to, fix the sod, blah, 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 all of these things. Doesn't respond, doesn't do what he's supposed to do, not doing it, not fixing the yard. What do you do? So one option is to pursue injunctive relief, try to go, ultimately get to a judge to say, we need injunctive relief. We need a judge to order this person to do these things that he is supposed to be doing under the declaration. Enforce our declaration for us, judge. Tell the gentleman he needs to weed his grass. He needs to replace the dead sod, whatever it may be. Now, that used to be a clear-cut option. Now, some of your governing documents might say something like the association has the ability to engage in self-help. The association could maybe hire its own contractor to weed that same lot, to replace that sod. If the governing documents say that, that might be something you have to do before you can go to court. So that's important to be aware of, because now it might be something where you cannot any longer go to court without having tried self-help. There was a case that came out that basically said injunctive relief is only when there's no other remedy available. If self-help is a possible remedy, you might have to engage in self-help. So again, in the world of associations, if it's something like a maintenance lawn type thing, that's an easy enough fix. But if it's something like we need Mr. Smith to replace his roof, well, that's a little bit different. Might not be able to do it because you can't take out a permit for someone else's property or whatever it is. But self-help is now an important thing to be aware of in your governing documents. If you have that authority, if you have that language, it might be something you actually want to take out. Maybe you don't want to engage in self-help. Insurance, we'll just gloss through this quickly. Associations responsible for obtaining and maintaining adequate insurance to cover the common areas. And then there's anything else they're responsible to maintain. You all should maintain D&O insurance. That's what covers, the board for any allegations of wrongdoing. Fidelity coverage. Although interesting fun fact, the board could actually have the owners vote to approve waiving the requirement to obtain fidelity coverage. Not sure why you do that, but it's an option. All right, we won't get into all of this. A lot of insurance stuff. Fair Housing Act, this is something we put in here again to give you guys the information. You can go through it later. I'm not going to go through it. We teach a whole class just on fair housing. The main gist is if you have certain restrictions, you may have people who are disabled and claim that they need an exception. They make, a request for a reasonable accommodation to a certain policy or procedure you have. If you are a no pet community, that means maybe they want to have an assistance animal, maybe they want to have a dog. If this person is disabled, if they give you the background that justifies essentially that request, that animal now is no longer a pet. That animal now is considered an emotional, support animal or an assistance animal, and you may have to allow that. These are things, you really want to be careful about, because again, you could be on the wrong side of a disability claim. You could be on the wrong side of a fair housing issue, and you do not want to deal with that. It's very expensive and you don't get those fees back. You want to make sure you are complying with all of the fair housing requirements. Talk to your attorneys. If somebody with a disability makes any sort of request, in these lovely photos, you see maybe somebody needs a ramp installed because they can't, get to their unit, or they need a different parking space, it may be assigned to them because it's closer or whatever it is. For you guys in the world of HOA, it's less so of a concern, but usually the pet thing comes up a lot and we want you to be aware of it.
I'll
Assistance
mention
animals.
too.
Yes.
I'll mention too, so you could have a little drink of water to have a little water break if you want.
Thanks.
On the firm's site at kbrlegal.com, we have an archive of some of our past courses and seminars, webinars, and videos. And the FFHA, animal and pets, there's so much material. We have courses just on that. So you can check out the videos. This one will be there in a few days as well. Just remember though, if you watch these videos, these recordings on our website, or if you share them with others, especially this class, the certification class, watching them on demand will not offer certificates or certifications or credits. You must be here live on the advertised date. So just keep that in mind there for review purposes only. Back to you.
Thanks, Jeff. All right, we're going to wrap up a couple last topics. So like we said, fair housing claims, you want to be very careful. Go to our website, watch the whole class. You'll get more information there, but there are a bunch of slides you guys can read through as well. Recall of directors, the big takeaway here, if you want to get rid of a director, if one of your board members, you're going to tell me, we really don't like Joe, we want him off the board. How do we get him off the board? Well, it would require a membership vote, and it requires a majority of your members to vote to remove him, unless he somehow, became delinquent and abandoned his seat or something like that. But other than that, it is a membership vote, majority of your members. There is a procedure in place. You could do it in a membership meeting. You could do it by written agreement. But the key is that's the only way to remove a director, and you need a majority of your total voting interest to support it. And there's a whole procedure here if you do it properly. Talk to attorneys if you think you're going to try and recall someone from the board. All right. Turnover, this is the last topic. Again, to me, we have the information in here for you. I don't want to get into the details. Ultimately, turnover is the whole process of going from the developer to a unit owner or owner-controlled community. There are certain requirements in the statute, what the developer has to do, what they have to turn over to you, what documents they need to give you, the process of, the election, all of that. All of that's in here. You guys can read that at your leisure. Again, I assume most of you at this point are probably post turnover, and that's all old news for you. And if not, we can still help you with it. But again, it doesn't apply to a lot of people, so I didn't want to get into the weeds with that one. All right, we wrapped up. I stayed under 2.5. Not too bad, Jeff.
You did well. You're the top of the pack with our team of attorneys and getting this done quickly. top 5 percentile.
It's not easy, guys. It's a lot. But
it's a
all
lot of
the slides
material
are there for anything I skipped through or didn't go into detail. You have it there.
And folks, as we mentioned, Emily's going to go through the Q&A and answer a few of them. Again, we're not going to get to all of them. There's a lot of you here, and a lot of the stuff was answered, and you're going to get the slides. So while Emily's perusing through some of the questions, I just put the link into the chat, okay? And I'll put the link into the chat again in a little while. So if you don't see the chat area, hit the chat button at the bottom. Just hover over the bottom of your interface, and then a bunch of buttons will show up. Press the chat button one time just so it appears. Again, and everybody listen up, it will say chat is disabled. Okay, I see people asking me these questions in the Q&A, even though I've mentioned it a few times, so please pay attention. It will say chat is disabled, but we can send stuff your way. It just means you can't send stuff this way. So press the chat button if you don't see the chat area, and I'll put the link in there again in a moment. And then when you click on that link, it's going to take you to this page here. This is what you fill out. And one of the more important ones where it says name, please do not use all capital letters, upper and lowercase only, okay? Because it does a script font on the automation process, all capital letters, you won't be able to make out your name. Upper and lowercase only, please. Another overlooked area is this one here. Did you phone in and listen? This is a required field. If you are only hearing us and not watching us, meaning you dialed in to listen only, that's where you're going to choose yes. If you can see us, regardless of the device, if you can see us, you're going to choose no. And then after you fill everything out, you submit it, and this is the confirmation screen. This is what it looks like. And it mentions here, it may take a couple of weeks to get your certificate. It won't. I'm just covering myself in case there are any tech issues. You'll probably get it tomorrow or, quick. You'll get it quick. And then this is also where you can download the slides on this confirmation page. This bullet here, slides can be downloaded. You click on that, and then another tab opens up with the slides. You can then print them or save them. I recommend saving them because printing 200 slides is going to send you straight to Office Depot for a bunch of ink. You're going to use up a lot of toner. I'll go over this again more slowly after Emily does a few of the Q&A. So even after Emily leaves in a little while, I will remain on to go over this even more slowly than I just did. So Emily, back to you.
Thanks, Jeff. All right, so let's scroll through some of these. So someone said, is a membership meeting the same as a board meeting? Are homeowners allowed to speak? The gist is, when we're talking about what meeting is what, membership meeting is a meeting of the members where the membership is voting. So maybe, again, typically it's usually just your annual meeting, and it's supposed to be your election. It doesn't have to be. You could have a special meeting. Maybe you're voting on an amendment. Maybe you're voting on something else. But typically it's just your annual meeting. Board meetings are where the board's voting. So those are different things. But ultimately, yes, your owners are allowed to be there and they're allowed to speak.
There was a question I saw very much earlier in the night. Can the president of the board vote?
Yes. Common misconception too. President still gets a vote. Keep in mind, when you're an officer, yes, you have certain tasks and duties if you're the president versus the treasurer versus the secretary, but ultimately you're all directors. Every director's vote counts the same. The president's vote doesn't count more than the secretary's. So if you're a board of 5 to basically make any decision, you really need three of you. And it doesn't matter who, in the world of which officers they are, you just need 3 people to vote. So it doesn't matter what position they have or what office they have. Someone said, if the election's over and the board still has a vacancy, do we need to call for an election to fill the gap, or can the board nominate and fill the vacancy? Good question. So ultimately, look at your governing documents. Typically the bylaws won't say anything, or if they do, they just say that the board gets to fill the vacancy. That's normally the way it reads. But ultimately, unless there's something strange in your bylaws, the board gets to fill the vacancy. So maybe you're at an annual meeting, we open up the floor, we had quorum, we open up the floor for nominations, we only have 4 people who want to run for whatever reason. We end up with, 4 seats filled in a board of 5. Well, what are we doing with that 5th seat? The other 4 can later decide, okay, we'll see who we can appoint. Maybe my neighbor didn't come to the meeting, but I think they'd be great on the board. And if I talk to them, they'd want to join. The rest of the, board, if that's okay with them, they could appoint that person at the next board meeting, motion to appoint Sally Smith to the board. Great. Sally approves. She's happy to do it. Everyone approves. Good. Don't have to do a whole other election just because you ended up still with an empty seat. How are yearly elections handled if we don't have quorum? That is the big question. So it happens a lot. If your process is we need quorum and we take nominations from the floor and you don't get quorum, then what do? The board's just going to roll over. You're not going to have an election. The board's just going to roll over. That's why we'll hear a lot of owners complain. I've lived in the same community and we haven't had an election in 20 years. We hear it all the time. And ultimately, the only thing you can do is encourage your neighbors to come out, maybe gather some proxies, get the numbers so you actually can get to quorum. But it's hard. I get it. If you're in a big association, maybe you never hit quorum and the board just rolls over. Not much you can do other than, again, encourage your owners to show up, maybe gather some proxies, see if you get there.
And folks, you're encouraged to stay for the Q&A, but if you filled out your evaluation, you can go to answer a bunch of people asking that.
Yeah. Can a person serve on the board if they don't live in the association, but they own a home? Yes. So essentially any member is going to be eligible except for the reasons that we listed before. So if they're delinquent, if whatever else, but you can't, it can't just be, well, they don't live here, so they can't be on the board. Not how it works. Can one person hold two positions on the board due to a vacancy? I'm going to assume you mean two officer spots, not necessarily, you know, two seats. But yes, potentially, depending on what the positions are, you could do it that way, yes. All right, let's see. Should board members, oh gosh, personal email, that's a good question. I see Robert said, should board members use their personal email addresses? Should the HOA provide board members with an email address to conduct association business? Good question, because you're right. Your personal email ultimately could be part of some discovery in a legal proceeding. If you don't want to use your personal email, I mean, I don't think the association has to provide you with a new email address. You could create your own new email address, you know, Robert at the Greens HOA, you know, or whatever, or Robert President of Greens at gmail.com.
Yeah, I was
Create
going to say, I've seen plenty of free ones
Yeah.
out there between Gmail, Yahoo, whatever, you know what I mean?
Yeah. You know, whatever it is. Let's see.
I do
If
that when I
someone
buy
wants
stuff
to-
online, so my
I
regular
know,
inbox isn't inundated with crap, you know what I mean? So,
right, just set up another one.
right.
Let's see. So someone does say we don't typically get a lot of members who attend board meetings. Sometimes we engage in conversation. We've allowed members to speak prior to the beginning of the official the official agenda, what's customary. Again, it's sort of what works for your community. I've seen that both ways. I've seen a lot of communities that are a little more casual with following the agenda and more casual with letting their owners contribute and speak, because everybody is, maybe you only do have a few homeowners that show up and you want to let them be involved. You want to let them talk, but you just want to be careful. If it starts to get out of control, if the meetings start to get a little too long, maybe now we want to think about limiting that participation. But really that's, it's going to depend on your community. Let's see.
Lydia, yes, if you submitted your evaluation, you can leave. You can go. You're welcome to hang out, listen to the Q&A, but if you've done your evaluation, the required portion of today is completed.
Some other very technical things. Someone said, what about satellite antennas? Good question. There's also language in the statute basically that you may have to allow certain things, certain satellites, certain energy efficient items. So, solar panels, you might have to allow those even if you don't want to. Well, you are going to have to allow them, bottom line, even if you don't want to. But again, you may have some control over where they go, things like that. These are, again, very specific items that come up in our lovely area of law. We can't get into all of them tonight. Someone said, is there a legal argument on Kaufman that's actually been settled, or is it being litigated? As far as we know, this is, again, sort of something that's really only been a hot topic for the last couple of years because of these issues with the statutes changing in this way. I have not seen a case that has actually come down yet, but that is the legal discussion. So I don't have a real answer for you on that. All right. This is okay. Well, this question is very funny in terms of oddly specific to the exact case law. If you have a seawall that needs repair and hill above seawall is being washed away requires a special assessment, but community doesn't approve or gain votes needed, is there something under the emergency criteria that could be used to move the assessment along? Literally, it seems like that's almost a law school question. That was essentially the facts in the case about necessary maintenance, necessary repairs. When there's a requirement for special assessment approval of the owners, if it's a necessary maintenance issue, necessary repair, that was the case law. It had to do with a seawall and a crumbling seawall. So just kind of funny, but I don't know in terms of it can be used to move the assessment along. Technically, there's, yes, the criteria for special assessment. The notice says, 14 days, but it does say unless there's an emergency. So in theory, if you have a engineer telling you that seawall will crumble in the next, 48 hours if you don't do something ASAP, Sure, the association could have their special assessment meeting, I suppose, if you don't have the 14 days that you need, but, a little scary to think that might happen, I guess. But yes, so there is some leeway there in terms of emergencies. All right. Da-da. If we can't get people to be on the fining committee, can we still issue fines? No, this is the whole problem, because you need to have a hearing. So the board first decides to adopt the special assessment, but or not the special assessment, sorry, the actual fine, but then the hearing has to happen and the committee is the one to impose it and to confirm the fine. That step is key. If you don't have that, you can't have the fine. I know, I get it. Boards have problems with this because we don't have anyone who wants to be on a fining committee. Let's say the violation is cured minutes before the hearing. Organizing a meeting has a cost. How can we recover this cost? You probably can't. It is probably just a matter of, cost of doing business. And like I said, this is sort of along the lines of even the additional administrative burden of the owners requesting records or doing all these things. And there's just an element of it's a cost of doing business for you guys. Sorry. I thought we could not enforce having a truck in the driveway. I know I use the truck in the driveway as my go-to example all the time. But again, now statute might kick in that says, right, you can't enforce that covenant, but talk to your attorney, see what your covenants are. Can we get a copy of the slides? You already said they're all going to get a copy, right?
I'll go over all that again when you're done with the Q&A. But yes.
Remove a director that was appointed applies the same way. Member approval, yes. So if you want to remove a director that was appointed, it's the same thing as if they were elected. The owners have to approve, majority of the owners. All right. What happens if a mortgage lender doesn't approve the amendment to the declaration? I haven't seen that yet. Because generally they don't pay attention, honestly. And it's a negative notice thing. You do a mailing, you send them the notice, and typically they don't answer, honestly. But there's still a threshold. So if enough of them approve it, there you go. Thank you guys for the kind words. I do appreciate it.
A long class. We appreciate y'all hanging out.
I know. Again, hopefully you guys had a snack, something, a drink. This is water, I promise.
Yeah, my peanuts.
All right. Let's see. Can you call code? That's another question. Basically, if an owner's not keeping up their property, could the board call a city code for a violation? Yes, but be careful, because depending again on your community and what the violation is, the only thing I just wouldn't want you to run into a problem where now somehow the association is getting a violation, because sometimes those code guys, those city investigators, you want to be real careful with those inspectors. But sometimes, yes, the city will do it for you, and you don't even have to, you don't have to enforce as a board. You can let the city take care of it if it's a obvious maintenance issue, something like that. Let's see. Can two members of the same household hold two seats? We don't have enough people. Yes, you can if you don't have enough people. Yep. All right. Someone asked about the Corporate Transparency Act. Okay. Let me mention that quickly, guys. So go to the website. The latest is if again, there's an update basically, because if you were affected by the hurricane and there's certain things in place, if FEMA applies to your county, if your, if the taxes were given an extension, whatever it is, you may have an extension now. But yes, ultimately, bottom line question, the Corporate Transparency Act does apply to HOAs. Your board members are going to have to register. So Corporate Transparency Act, if you guys don't know about this, it's a federal law. It kicks in. You were supposed to by January 1st of this year, of upcoming. So we're 6 weeks out. You were supposed to file and register all of your board member information with the federal government. Go to our website. We keep putting updates there because now, again, the latest is potentially there might be an extension of time if you were impacted by the hurricane. Go to our website. It's an interesting.
Yeah, just put a link into the chat from Jeff's roundup.
Okay. Oh, geez. So many things. Somebody asked about an EV charger. Again, so many different topics we could get into, guys. All right. All right. I think we're wrapping it up. 2.5 hours in. I think we touched on basically everything.
We did. Emily Great job. Thank you. And one last time before you head out, and folks, even when Emily leaves, I'll stay on to answer any techie questions about like somebody asking about printing the slides. I'll do the best I can. That's going to be up to you because I don't know what browser you. All the browsers are different, but I'll show you how I do it on this one. But Emily, one last time, what are the best way for people to reach you if they want to get in touch with you?
You can shoot me an email. It's right there. Just egannon@kbrlegal.com. Our website is pretty easy. It's kbrlegal.com. You can find all of us there. And lots of information, like I said, about all of the topics we've talked about today. Classes on pretty much all of the topics we've talked about today. Today is meant to, like we said, sort of be your HOA 101 basic. Let's talk about everything, but we can't really get into too many details.
Right.
So we have more detailed information there for you.
Thank you so much. I know you need to skip out. I'm going to hang out a little bit and I
All
will chat
right.
with you
Thank
soon,
you
Emily.
guys. I appreciate it. Hope everybody has a good night and a good holiday next week.
You
All
too.
right.
Happy Thanksgiving, Emily.